what I would call your daughter's home in South Fulton?
Things got so bad and threats got so many, even against me, that the house became basically uninhabitable. I got tired of sleeping in one room one day and one that. I would say December of 2022, something like that.
December of 2022.
Right. That's about right. Yeah.
Now, let me change and go back for another date. You had indicated, and I didn't hear it. When was your daughter, Miss Willis, when was she sworn in as district attorney?
On January 1, 2021.
Okay. And did you indicate that there was an incident, and I know you've described it, was that incident on February the 3rd, 2021?
That's my best recollection.
Okay. So my question then is, after February 3rd of 2021, how much longer did Miss Willis stay at the house before she moved somewhere else?
Very short period of time, and I cannot be precise, but I would bet all the money I ever made, it wasn't more than a month and a half, if that long.
Okay, so we're talking about, best of your recollection, end of February into the break of 2021, when Miss Willis would have moved to a different location.
Exactly.
Okay. And did Miss Willis return to the house, that is, the house that you were in, at any point in time that you can remember?
From time to time, she and her security might show up for her to pick something up or take something or something, but she always would come with her security.
Okay. My question was poorly worded, I apologize. Did she come back permanently to her house?
Oh, absolutely not.
Okay,
absolutely not.
So as far as you're aware, that once Miss Willis left the house, her house, South Fulton House, so the record's clear, in either late February or into March of 2021, best of your recollection, she's not returned to that home to live.
No, it became uninhabitable. It just,
That's okay.
I would have to walk around that house looking out of every window. I made a habit of having to walk around the whole house. I got lights so that if somebody would come at night in the back, so that those kinds of reflecting lights, I had those put up.
I don't again,
yeah. Okay.
All I was interested in is whether she had ever returned.
No, the answer is no.
Okay. Now, when Miss Willis, when your daughter left the home, time period, end of February, beginning of March, give or take, 2021, do you know where she moved to?
No, and I didn't want to know. I intentionally did not want to know, because I was not, if somebody stuck a gun to my head and I could tell them, I wasn't going to tell them anyway. I'd have made up something, but I didn't want to know.
Okay, so would it be fair to say that if you didn't want to know, you never visited her at the place that she moved to?
Oh, I never did.
Never did.
Never did.
Okay. Do you know how long she stayed at the first place that she went to after she left her house before she moved to a second place?
What I know, and this is hearsay, counsel, is that my daughter has had to move something like 4 times.
But do you know any potential?
No, I don't know any place. I was taken one time for Christmas Day. I've only seen my daughter, and this is very hard for me to say, but during the period my daughter left, I've met my daughter 13 times, because I can't, and we've never seen each other more than maybe 3 hours, because of the nightmare threats against her and me.
And I understand that, and from the perspective of being a father myself, I understand what that means. So I'm going to move away from that. I was just trying to get an idea of date wise. Okay, so let me try to get one more date. In 2023, when you were being interviewed by one of the gentlemen that wrote the book at the DA's office, and Mr. Wade came in, can you give us, other than 2023, what the date would be?
I'm sorry, I can't, counsel.
How about spring, summer? Any idea?
I would guess spring or summer, but I can't.
Okay.
I don't. I'm sorry.
And you've already indicated, at least to your recollection, that was the first time that you'd met Mr. Wade.
Oh, absolutely.
Okay, I'm not arguing with you about that. I want to go to Miss Willis's boyfriend that you referenced. Okay, you met Ms. Willis's boyfriend, as you've characterized it, when you came here in 2019.
Correct.
And you met him on one occasion, several occasions?
Oh, no, I saw him often.
Oh, so you mean there was no secret that she was dating this man?
Not from me.
Not from you?
And not, he was he was a disc jockey of some kind. I think he had a government job during the day. I don't know what it was, but apparently he would do weddings and so forth and so on. He was a disc jockey, play music. So he had all his stuff was always in the way, and I was always having to try to push it aside. And anyway.
But Ms. Willis, your daughter didn't keep him from you, correct?
No.
No, I mean, there was no doubt
I mean, we lived in, my daughter and I lived in the same house. I mean, he came and went,
Right. Now, when did you learn that your daughter had a romantic personal relationship with Mr. Wade?
Well, about 7 weeks ago, when as a matter of fact, I just found out when other folks found out. Okay.
That is, your daughter, as I understand it, never told you one time in the year of 2022 that she was dating Mr. Wade, correct?
That's correct.
And until recent, that she dated Mr. Wade, correct?
That's correct.
That is, whatever the relationship is between father and daughter, she kept that a secret from you, correct?
Correct.
That's all I need to know.
Mr. Stockton.
No.
Good morning, Mr.
Good morning.
Floyd, correct?
Yeah. Good morning, Council.
When your daughter moved or left the house that she owned, did she say anything to you about having a large?
No, see, maybe, excuse me, and Your Honor, I'm not trying to be racist, okay? But it's a Black thing, okay? I was trained, and most Black folks, they hide cash or they keep cash. And I trained, you always keep some cash, because I've been places, and just because of the color of my skin, for example, I took a fellowship at Harvard when my daughter was just if I might, Your Honor, when I was just, she was just, maybe 3 years old. And I remember going to a restaurant in Cambridge, Massachusetts, and I had a American Express credit card and maybe a Visa or whatever. And I had a lot of what they call traveler's checks. I don't even know if they still have traveler's checks, but traveler's checks. And there was a sign said, with the credit card. For whatever reasons, the man would not take my American Express credit card. So I pulled out my Visa card, and he wouldn't take my Visa card. So then I pulled out my traveler's checks. He said, we don't take checks. Now these were traveler's checks. This was money. I had a $10 bill. I'll never forget this as long as I live. And he said, the bill for my wife at the time, Fani's mother, Fani, and myself was like $9.95. And I had a $10 bill. That was all that. I always remember that. But even before that, I've always kept cash, and I've told my daughter, you keep 6 months worth of cash always. For example, I had 3 safes in my house. I put some of my clients' stuff there too, things I didn't want other lawyers to be, because you're always in a firm, and I knew that there were special conditions. So some of my clients' things I would bring home, put them in the safe. But I've always kept safes. And as a matter of fact, I gave my daughter her first cash box and told her always keep some cash.
So is that a yes?
Yeah. Oh, absolutely.
That's all I got, Judge.
Mr. Durham.
No questions.
Mr. McDougald. Thank you. Mr. Rice.
No question, Your Honor.
Mr. Gillen.
It's still morning. Good morning, sir.
Good morning, Counsel. How are you?
Just fine. Just a few questions following up. when you were talking about when you learned about Mr. Wade and your daughter, correct?
Correct.
Now, did your daughter tell you in around October of 2022 that she had gone on a Caribbean cruise with Mr. Wade to the Bahamas?
The answer is I knew that my daughter had gone, but I did not know who she went with or what the circumstances were. So I knew that she had gone out of town, but I didn't know with whom.
I see. And did she tell you in November of 2022 that she had gone to Aruba and stayed at a Hyatt Regency resort there in Aruba for 3 days with Mr. Wade? Did she tell you that?
The answer was, again, I knew she went out of town. I didn't even know where she went. I knew she was going out of town. She told me she was going out of town. I think she might have said she was going out of the country or something. She'd be gone. But other than that, that was all.
Okay. And did she tell you in March of 2023 that she was going to Belize for several days with Mr. Wade?
It's the same answer that I knew she would tell me she was going out of town, and she may or may not have told me where she was going, but she'd be gone for a couple of days.
Okay. Now in 2023, you were in many days you would be out in California, correct?
Some days I'd be in California, correct?
Okay. Well, did she tell you in May of 2023 that she was traveling to Napa Valley with Mr. Wade, so maybe y'all could see each other when she visited California with Mr. Wade?
The answer is no.
And so the first time that you ever met Mr. Wade or learned about Mr. Wade, to your recollection, was in 2023?
That's correct.
That's all I have, Your Honor. Thank you.
Mr. Kucherov on Zoom.
Yes, Ron, just a couple quick questions. Good morning, sir. I know I can't see you.
I can't see you either,
We
but
can take a moment.
good morning, Counsel.
We take a moment. Let's just pause, see if we can change the screens to show Mr. Kucherov.
Your Honor,
Good
I'm on a phone, so it's kind of difficult
Can you turn your screen on though?
trying to. Does that work?
Just to hold one more moment. All right, there we go. You can proceed, Mr. Kucherov.
Sir, you seem to know about the issue of cash in this transaction. You said it was a black thing. How did you know that the cash was going to be an issue in this testimony?
Because I was asked for it and I was prepped by the lawyers and they asked me about it. What else?
And did you speak with Mr. Wade about your testimony?
No.
Did you speak with your daughter about your testimony?
She may have been present when the lawyers were. I really don't remember.
If Mr. Wade and your daughter were dating, you wouldn't have known that unless your daughter told you.
What are you, maybe I'm not understanding your question, Counsel. So maybe you want to restate. What is it that you're asking me?
Yeah, if it wasn't clear, I can re-ask the question. I'll rephrase it.
Yeah, right.
Mr.
Yeah,
Wade,
please do.
if Mr. Wade and your daughter were dating, you wouldn't have known that unless your daughter told you.
I did not know that they were dating.
Judge,
And
I
when
have
were you
nothing
talking
further.
about the cash? I didn't know that. I don't know what you're asking me. What I told my child from the time she was a child is always have some money. Always have some money. If you go on a date so that people don't try to stick you and you want to leave whoever, always keep some cash, okay?
Mr. Floyd, you answered the question that the attorneys prepped you for that. So that's all I wanted to know.
Anything else, Mr. Kucherov?
That's it, Your Honor.
All right, Mr. Cromwell.
No questions, Your Honor.
Mr. Abadi?
Dude, Your Honor. Mr. Floyd, now it wasn't common for your daughter to confide in you about her romantic life at all.
No, and I haven't confided in her about mine before when I had one, okay?
Hate him.
And you wouldn't have known about her boyfriend.
Hey, Debs.
that an objection?
I think that might have just been a still off mute.
Okay.
Let's keep going.
Now, you wouldn't have known about her boyfriend, the disc jockey, had you not been living with her, correct?
That's correct.
I'll allow overruled.
I have nothing further.
Did he answer the question?
He did.
Okay.
He said that.
All right. By show of hands, any redirect on those points only? Ms. Merchant.
I just want to know when you were prepped by the lawyers, when this prep session was.
I just got off the plane on, what was it, Tuesday night? I think I was probably drooling at the mouth. I was so tired. So it must have been, I got in Wednesday. It must have been Wednesday.
And did you talk about any of the testimony from yesterday or watch any news reports or anything like that?
Oh, absolutely. You can't cut the TV on without seeing this. The first thing, and I listen to conservative radio a lot, and, last night for 5 hours, all they talked about was this case.
So you were aware of what the testimony your daughter gave yesterday was?
Yeah, unless you don't cut the radio on, unless you don't cut the television on, unless you don't read the AJC or any other, the New York Times or whatever, which I do every day, yeah, of course.
So is it fair to say nobody instructed you that you were under the rule of sequestration?
Right, and I'm not under subpoena either.
Thank you.
All right. Anything else? Seeing and hearing none. Thank you, Mr. Floyd.
Thank you very much, Your Honor. It's a pleasure to appear in front of Your Honor.
Thank you.
Thank you.
All right. Ms. Cross, let me check in. Was the state planning to call additional witnesses?
Not at this time, Your Honor. We're trying to accommodate if there's a
Sure.
lapse in schedule to be able to this afternoon. But right now, that was our last witness.
Okay. So even if Mr. Bradley testifies to some extent, there's still the potential that the state has no further witnesses?
I anticipate at least one more will be available this afternoon, but that would be it.
Okay. So there are potentially more state's witnesses. All right.
Judge, before we move on, I'd move to strike the last witness's testimony because of violation of the rule of sequestration.
All right. So I think the rule is invoked and the instruction was for the parties to tell all witnesses subpoenaed or expected to appear about the rule. I don't think the remedy is necessarily striking. I think it can go also to this credibility as well. So to that extent, unless Ms. Cross, you want something else to be heard on that, point is made. All right. Do we have an update for Mr. Bradley?
Yeah, he should be here at 12:25.
Okay, then what I think we should do is have these preliminary conversations about privilege, see if we can make any headway, and then take our afternoon break. So to that end, counselors, I don't know if you just want to argue in place there or go to the table, whatever makes you comfortable. But Mr. Chopra, I think maybe it was relayed to you since you weren't in the court earlier this morning. We'd had some initial conversations about the distinction between the privilege and Rule 1.6, and it sounded like you wanted to be heard on that.
Your Honor, it was brought to my attention. And I apologize because I don't have things.
What do you need?
Well, a copy of the case in front of me would be helpful, but it's not necessary. It would just take me a second to keep looking at my phone to respond to the court.
Whatever you need to do.
Your Honor, I believe case for in anticipation of piercing the rule 1.6 is owns Corning Fiberglass versus American Centennial. Is that correct? Pardon me, Your Honor. It's difficult hearing counsel. Could you?
Yeah. And there's a microphone there at the jury box. You can try to
Hear what he's saying. Thank you, Your Honor.
either try to lift that microphone up and speak in the jury box or make your way over to the podium or table. Sorry?
Is that any better?
All right. And no, that was authority provided by Mr. Sadow over our morning recess. And I think that was indicated to go more towards a potential crime fraud argument. I don't think we've really gotten there yet.
It's not crime fraud per se. It's the same notion. It's brought on the court, different propositions.
Okay.
But yes, and to attorney-client privilege waiver.
Right.
1.6 confidential and secrets waiver.
The case that I had cited to this morning showing the distinction between the two was tenant healthcare. So that's where we were on the threshold issue. Did you have something that you wanted to address on that?
I've not been able to review that, Your Honor. I was unfortunately unaware.
All right, Mr. Ward, you're co-counsel with Mr. Bradley?
Not here in that capacity.
Remind me why you are here.
I'm here just assisting. I'm here just assisting with Mr. Bradley, and I'm assisting with the counsel, his counsel.
Okay, so you are co-counsel on this.
Oh, this morning when you were asking where he was, I had to make sure everybody knew, this here. That's what I was doing, just informing you.
Okay,
Oh, this is, but the judge is saying it's tenant.
right. And the citation for that's 273 Georgia 206.
Judge,
And I'll give you time to review that. In the meantime, what other things that you want me to know? And perhaps at this point, we just take our break now, unless you also want to talk about the questionings that were provided by Ms. Merchant, seeing if there's anything we can achieve.
so that I can be clear, it is apparent that at this point, we're going to go into whether or not 1.6 provides privilege for Mr. Wade, even though he has specifically stated that he does not waive that privilege. Therefore, it would be incumbent upon the court to issue an order to demand that Mr. Bradley, over and above the privilege afforded in 1.6, is required to testify. Is that correct?
That's right. That's what we covered this morning.
And so I would ask the court, is the court then going to travel under the fraud exception?
We haven't quite gotten there. We haven't decided whether attorney-client privilege applies. I think there are some other things that we would have to do to, I think we got held up yesterday on 1.6. As I understood it, I was waiting to hear from you whether we are now beyond that. And then if we're in the land of attorney-client privilege and only attorney-client privilege, so Rule 505, then I think Mr. Sadow has some arguments on crime fraud. And I think there's also just the general arguments of, does it exist? Were certain statements in furtherance? Does Mr. Bradley have any knowledge independent of those?
Certainly.
Right.
And in order to keep the court abreast, yes, we are still traveling under, there should be a privilege afforded to Mr. Wade under 1.6. And we are aware of how they will try to convince the court that that should be overcome. So I hopefully I can read this
Sure.
case in less
Okay.
than 5 minutes.
All right, that's fine. Anything, I guess, as he reads that, let's do this. Assuming we do get beyond 1.6, if you can work with me here, anything we want to add to that?
I'm afraid I would have to hear what the arguments were that got us past 1.6.
Okay.
I'm not here to insinuate to the court that we would do something else. I don't
Okay.
know.
But there was a line of questioning that Ms. Merchant decided to write out and share with the parties. Were there any initial thoughts, comments, reactions to that? Again, just trying to make sure we make the best use of Mr. Bradley's time once he arrives.
Your Honor, I just want to say that that might just reiterate that my client has not waived the attorney-client privilege. The questions that we reviewed this morning, Mr. Bradley is not able to testify about anything relating to Wade's marriage or dating history after December 2018. That's going to be operative days. Nor does any of the questions Mr. Bradley cite to any external knowledge or sources. Anything he will say would be derived entirely from privileged communication with our clients. So we just want to renew our approach.
Okay. So certainly the assertion of the privilege is confirmed and for the record. And I think, again, this is where we got held up yesterday is that I know you're asserting that certain answers to these questions would be covered by privilege. I think there's still some boxes we would need to check before we can confirm that. And we'd have to check those boxes with Mr. Bradley before we can get there.
Certainly, Judge.
Okay. If there's nothing else, then let's break until 1 o'clock. All right. Thank you all.
Thank you.
Yes.
You need to break today. I will do that.
I mean, I don't know.
One more. Yeah, I think I'll have one more witness. Yeah.
Maybe we'll be done.
I got things to do. That's right. Everybody knows what I'm doing.
Yeah.
I never got to try the case.
Partly before the trial.
I'm so sorry.
Oh, do you lose a defendant or something?
Well, here's the thing, that's really complicated. They had lost the defendant and back in 2021. And then everybody.
Nobody noticed?
So I get printed 5 months before. And then all of a sudden, Wednesday, they filed a motion to fix it. And I said, the lawyer. I said, "Oh, they didn't put it in the free files. I moved it, they waived it, the judge. It's like, no, we're gonna go.
I never want to see you again.
I've done this once, I'm getting on the street.
They are?
Like waving to them, yeah.
You're in good view of the camera there.
Yeah, right.
Did you get yourself a snack?
I ate the other half of my sandwich that I had brought yesterday. Because I only had such a quick break yesterday.
Yeah.
Did you?
Nah, no.
No? You don't think it's gonna be a long day?
It's gonna be a longer day, but probably not as long as yesterday. I never really eat much almost 7 in the morning. It kind of clouds the brain.
If I eat a big lunch, I will feel like I need a nap.
Yeah.
Yeah, usually I try to keep it light, I just don't.
Right, he's in Miami with this lawyer down there. His lunch was a Cuban cigar and 2 shots of espresso. That was it.
I cannot imagine, I don't drink coffee, so the thought of 2 espressos is special shots. Attorney Little, I know I've said hi to you a couple of times, but I don't think I've actually introduced myself. I'm Claudia Kelly Bazan with the Fox News. Nice to meet you. Yeah, I know you're here. I'm usually the one who has the Fox, so. Just wanted to say hi. Yeah, you too. I appreciate that.
Come on, I'm channel with us. You know, tell us what's going on in life. Just. So I assume you got nothing.
Nothing.
Pretty much.
Yeah, no.
It was absolutely horrible. Where'd you go? Oh, yeah.
Yesterday it was like Atlanta Bread Company, and it was pretty good, you know. Oh, I shouldn't say pretty good, it was chicken salad and, you know what I mean?
You've been to the Wing Cafe down there, right?
Yeah,
It's not bad. I'm gonna steal one of these sparkles.
it's actually taking minutes, but we're good. Some of the, like, coverage.
Lemon lime pasties.
That's right. Whoa. You've had some very interesting folks, sorry.
Yeah, so you might remember me from
I read, was that when I was it? On the Court of Appeals? Who's I representing? Somebody, right?
Yourself.
Me? No.
I think it was you.
No, I was supporting somebody. Billy Spruill,
Billy Screw.
right?
Yeah,
We never felt that he didn't have something to say.
yeah, they messed up with the record transcript presentation.
Yeah.
But she learned from that one.
Yeah, I figured you might.
Don't put the antics on the record.
Huh?
She learned from that one, to put the antics on the record. Yeah. I was there for that.
That was a while, right? How many years? What are we talking about? How many years?
That was in the eighties. That's how old you are, not me.
I know, I would never say that.
I don't see what going where. Yeah.
How about that? You see? Mr. Bradley here.
He's over there.
Oh, that's it, Judge.
I got that. Is that him?
Are you sure? We can't have a future discussion? Maybe somebody else?
Who calls him?
Remain seated, go and now come to order.
Thank you all. Please stay seated. Hi, Ms. Taylor. All right. All right, we are back on the record. Beginning with the state and then to Ms. Merchant, anything we need to take up before we proceed?
No, Your Honor, I've alerted the defense, just for the court's planning purposes, the state doesn't intend to call another witness.
All right, thank you, Ms. Cross. All right, Ms. Merchant, you can call your next witness.
I'll recall Mr. Bradley.
All right, Mr. Bradley, welcome back. And just to remind you, you're still under the requirements of your oath administered yesterday. Do you understand that?
I do.
All right, thank you, sir.
Good afternoon, Mr. Bradley.
Good afternoon.
Before I begin, I wanted to ask you if you wanted to clarify any of your statements that you made yesterday.
Go ahead and begin.
I wanted to ask if you wanted to clarify any of your statements that you made.
Go ahead and ask whatever you're gonna ask, Ms. Merchant.
You initially became involved in this matter because you called me. Correct?
Absolutely not.
I didn't call you.
No, it was through a third party.
You called me after you read an article in, and I don't even know where it was. I found one in the Washington
Your
Examiner.
Honor? I've got an objection. Can we approach the bench?
Okay.
Well.
But I can alert the court broadly to my concerns. This witness, it appears from the questions that Ms. Merchant had proposed, don't differentiate between what I'm considering three kind of buckets of information that this witness might have. One is communication derived from his representation of Mr. Lee. Second is any information that he might have from personal knowledge. The third category, which I believe is the substance of what Ms. Merchant wants to go into, is information not derived from personal observation, not derived from communication with Mr. Wade, his client, but gossip, secondhand, thirdhand, speculative things. Ms. Merchant's questions don't differentiate those categories of information. And I'm concerned about the questions being proposed without that qualification so that Mr. Bradley doesn't know when to invoke a privilege. I think the testimony yesterday was he didn't have any personal knowledge of any of this. That was my understanding of the testimony. I believe that was Mr. Bradley's sworn testimony yesterday. And my concern is that the gossip part, the unsourced hearsay is where we're going to get to really fast.
Sure. And I think that's a fair point. I think she's following the script that she already provided you. So we have more than enough notice of when that might be coming. I think the second she asks a question that you think might weigh into that, make the objection and we can rephrase if necessary. All right, Ms. Merchant, you can re-ask that last question.
Read an article that was on September 11th discussing how much you and Mr. Wade were handling me, correct?
That is correct.
And you called me that same day and left me a voicemail on my cell phone asking me to call you back.
I do not recall that, but I do not recall that.
You don't recall that?
I do not.
So it's possible that happened.
I do not recall calling you after the article came out. I was shown the article, but I do not recall calling you after the article.
Can you tell us your phone number?
It's 334-717.
Wait, hold up. Why is that relevant, Ms. Merchant?
Because I need to establish that his phone number is the one that all of the texts that he had with me.
Can you just ask him if he has texted you at some point? We can stipulate that as a matter of record. We don't need that on the record.
Okay, we don't have to put it in the record. How about this? Can I show him a copy of his what he saved in my
Sure.
phone? Okay, I'll just do that. Now approach Judge.
You may.
Take a look at that and just verify if that's your number and your cell phone.
That is my number and my cell phone.
Okay, and is that also your email address?
That is my email address.
Okay, great. Thank you. And I'll keep that separate, Judge, and we can redact it. So after whether or not you left a message on my voicemail, the next day, we were all in court in front of Judge Harris on September 12th, 2023. And do you recall that?
I do recall being in Judge Harris. Yes, I do.
And your attorney, BC Chopra, was there, and I was there, and another attorney, Burt Cohen, were there, correct?
Those people were there at the time. BC was not my attorney. I didn't realize I needed an attorney until I was subpoenaed.
But BC Chopra was there.
I'm going to object to the relevance of this.
Ms. Cross, as I see this line of testimony, much of it is I'm taking in response to the original, how we started off this whole hearing, that Ms. Merchant had no basis whatsoever to bring this and she should be sanctioned. And I think she's laying that out. Okay. All right. Ms. Merchant.
I recall it was in a conference room in the front. I don't know. I know you were handling a case in Judge Harris. I think I was speaking to Bert about a case, and BC was there to speak to Bert about a case. Yes, I think I do recall that happening, but I can't recall Who else was there? It was a regular court date.
That conference room, that's sort of in Cobb County, there's a conference room in front of it.
Correct.
And it's not a public room, it's sort of like the jury room.
Correct.
And it was the four of us in that room talking.
I don't recall if anybody else was there. I will say that I do remember at some point it was myself, you, BC, and Bert there, but people were coming in and out of the courtroom, so I cannot sit here and accurately say that somebody else wasn't there at the time.
We talked, I mean, and people could have come and gone, but essentially
Correct.
we talked for the better half of
No, it wasn't an hour.
an hour. And that's the only time we spoke in person about anything related to this matter, correct?
Correct.
And based on that phone conversation, I told you I had been submitting open record requests and I was going to continue to submit open record requests, correct?
Based off what phone conversation?
Based upon our conversation in court.
Oh, okay. Correct. You said that you were doing some open records requests, correct?
And based on our conversation, I told you I was going to do some additional open record requests.
Which open records request are you talking about?
Just any, just asking if we talked about that I was going to be doing some follow-up to Fulton County. I can specify that.
Okay. Because I recall open records requests being made for other things, and so I don't know which one that you're referring to.
At that time, we talked about getting, I guess it's called a county card and getting access cards and things like that for coming in and out of Fulton County for you, Mr. Wade.
Okay. And
all of the access that you all have.
yes. And you asked me, did I have an access card?
And you are the one that told me that you and Mr. Wade, or that Mr. Wade at least had an access card.
I told you that the three of us had an access card because we had a contract with the DA's office or the county. I told you what those contracts were and that we had an access card that will allow us to pick up the documents, go into a specific office, and leave out.
So we talked about that badge access card and asking for that. I was going to ask for that, right?
Correct.
And then a couple days later, I sent you a text. And then when I say a couple days, so that was on September 12th when we had that conversation.
Do you mind if I pull out my phone? Okay.
On September 14th at 6:38 p.m.
And what day was this?
It was September 14th.
September 14th, correct.
And I sent you a screenshot of a Fulton County open records request I did.
Yes, and I said, wow.
And then and then we continued to text.
Wait. And then you sent another text about a badge, and I did not respond. You sent another text about an entrance card. I did not respond. You sent another text about some other badges and with a circle around it, and I did not respond.
Okay.
I'm sorry, thank you.
All right. Mr. Bradley, if you could just respond to the question asked and only the question asked.
That was
Thank you, sir.
actually, I have an additional
Okay.
thing I want to raise. Ms. Merchant provided some text messages that she let us know that she was going to refer to. The text messages are inconsistent with Mr. Bradley's exchange as he apparently is reading it off of his phone. So if I could ask Ms. Merchant, is this it is true, accurate, and complete? And perhaps we can see what's on Mr. Bradley's phone. But more importantly, I am going to object. I understand the court's leeway about Ms. Merchant
Sure.
being able to establish contact based on previous statements made. But I'm concerned about going into the content of the statements without putting things in the buckets that I've identified.
Sure. And so am I, Ms. Merchant. I'm not seeing so much the relevance of it back and forth. I'm allowing you to establish, the contact that was made and line with the outline you provided me. And I think we're on track with that. Were you planning to tender these text messages?
I'm discussing them with him. Now, if yesterday he said we didn't text about this case, so if that was his testimony again today, then yes, I would show them to him to refresh his recollection or to impeach him. But Judge, their first part of their argument is foundation, is what I'm assuming. They're saying all of these. They're not all relevant. I can give you all of my texts, but they're not all relevant. And so they asked for screenshots, and so I took screenshots. If there's a way to submit my entire text history with Mr. Bradley, then that's fine. If they want us to read every single text, that's fine. I just don't want to be in a position where people are saying that I'm not.
Well, I also want to avoid the situation where you as counsel of record are having to lay the foundation and do that sort of thing yourself. So I don't know how much further we can go with this before we get into that. So
Well, I'm not sure what their objection is. So I asked him about one question and he read
sure.
off several.
Why don't we just go with your next question and we'll see where we go from there.
All right, let's see.
But so, and
Apparently, when she wait for her to ask a question.
I understand that, Judge, and I'm not
Well,
trying
apparently
to
you don't, sir. Wait for her to ask a question and you'll have a chance.
So I think what the last thing I asked you was about September 14th. So those texts that you're talking about, those refer to the issue that we're here today about, though.
Some text did, yes.
Yes. Okay. And then you called me again on September 15th, 2023, and we spoke on the phone.
I do not recall that.
Well, I texted you and said I needed to call you back, and then I later called you back.
I'm not sure. I do not recall.
You don't recall that? Okay. And do you recall the following Monday?
Your Honor, I appreciate the question as it is on the form. And if the question is what she's going to read, I object to it even being asked out loud without knowing, number one, the relevance of it. If the witness is going to answer his source of information, and I feel like it is so inflammatory as to say out loud without knowing where Mr. Bradley falls on that, then I do have an objection to the question.
Okay. All right.
With all due respect, if I might just a moment. Why is it that we're not allowed to ask questions? And then when the question is asked, there's an objection made either by the state or the lawyers for this particular witness. It appears that what the state likes to do is force us to tell you in advance every question you're going to ask before there's an objection raised. And I don't understand why they get to do that when we are obviously in the same position to say to them, tell us every question you're going to ask first. I realize it's a privilege, but that can be the questions asked, state objects, interpreter objects, and the court rules, but not being able to put it on the record because it's inflammatory or it's somehow prejudicial. I don't think that, I'm just suggesting.
Sure. So, Mr. Say, I'd agree with you in the general sense of things, but in this situation, Ms. Merchant offered to provide essentially her list of questions in advance, giving us a preview of what she's going to say. And that puts us in kind of a different posture in that respect, where we can actually have some sense of what's going to come out. But Ms. Merchant, I think knowing what your next question may be, since usually we don't have that opportunity, does it presuppose some knowledge on his part that we have yet to establish is inside or outside of privilege?
Well, the first thing, Judge, is I gave these questions so that we wouldn't be in a situation
Sure.
where we were objecting and having 4 different lawyers talk about privilege, confidentiality, every single question. So I was hoping that we would ferret that out ahead of time. So this is the first that I've heard that objection to question 18. I did give the state copies of them as well, trying to be completely transparent. I also, I have to establish that his information, there have been statements in this court that I lied, multiple statements yesterday. I can't even tell you how many times that was said under oath yesterday, and that I did not get this information. And so I have a right to.
Which I've already said we can do and we can go over, but and we've already started doing that. But the next question, as you plan to ask it, may presuppose again some information that he has that we need to determine whether it's inside or outside of privilege. Is that right?
No. Well, I don't believe so. No. I mean, if we're going to talk about the privilege, I wanted to talk about it beforehand, which is why I gave all of these. I didn't know the state had objections on these questions to privilege. If we're going to talk about the privilege, I'm happy to ask him the substance of the question, but that is what I'm getting objections for. So I'm trying very carefully to craft something to avoid that. But happy to just ask outright the question.
Right. I don't see a way around that, Ms. Cross.
I understand, Your Honor. I'm gonna do whatever you tell me to do. The problem in the context that Ms. Merchant is posing the questions is, this was our communication, this is what I asked you, this is what you told me, and here are these texts that are supporting it. I understand the court's ruling that based on how things have gone, if Ms. Merchant feels like she needs to establish there was contact and communication, then I don't have an objection to that. However, number one, the text message that exchange that the merchant gave me is apparently not complete. And so I don't know, like, without making her a witness, how the state can, we're entitled to, if she's going to refer to text messages, we're entitled to an accurate representation of what those are. Mr. Bradley's looking at his phone and that's what he's got. He isn't under no obligation. Ms. Merchant provided those to us and I appreciate it, but I can't tell as I'm sitting here to an incomplete or an inaccurate recitation if what she gave me isn't complete.
So a couple things come to mind. One would be that anything the witness is referring to on the stand, counsel at any point has the right to inspect. And so if that's what you're asking for, Ms. Cross, then I think you have a right to do that if you decided to do that. The other is as I've seen it so far, I don't think these texts are coming in as substantive evidence, but more for impeachment, in which case extrinsic evidence would never be coming in to prove them up. And he either takes her answer or he doesn't. And that's how it works. So I don't see the foundation issue or the completeness issue really playing into it as it comes to impeachment.
If they asked me for the relevant screenshots, I took them. He doesn't have an iPhone. I can't download the entire text message history. I told them they could go through my phone. Like, I'm hiding something.
All right. All right, Ms. Merchant. I think at this point, again, I don't see anything extravagant about the next question on his face. I think we need to deal with it as it goes, so you can proceed.
I asked you where I could get an affidavit from about the affair. And you responded, no, because you didn't think anybody would freely burn that bridge. Isn't that true?
If you say so. I mean, I don't.
You have your text if you need to refresh your memory. September 18th at 3:11 p.m. if you need to.
Can you repeat the question?
The question is, did I text you asking you if you knew who I could get an affidavit from about the affair? And you responded, no, no one would freely burn that bridge.
Yes, I do see that.
Then I asked you if Chris Campbell knew, correct?
No, you asked me if under oath he would testify.
I'm gonna object to the source of the witness's information about that, whether that's firsthand information or not. And Mr. Campbell, of course, has a privilege too.
Well, since Mr. Campbell hadn't even been brought in to this proceeding at all, I'm also wondering about just the relevance of asking questions about Mr. Campbell.
I'm just, it's been objected that I'm not asking about all the texts and I'm selectively asking, so I'm trying to go through all of them. I would much rather just ask the very relevant ones.
Well, I have an objection to her asking. I can't tell if the statements or the testimony provided is consistent or inconsistent without a complete set of this text exchange. And it's not clear in the text exchange what the source of Mr. Bradley's information that he's providing is. And so that is, I'm struggling,
Sure.
and I know everybody else.
And again, I think you're focusing more on the merits than the impeachment value, right? If the sole purpose this is coming in is under those grounds, then you being able to word, I don't see that as being the necessary prerequisite. But as it relates to Mr. Campbell, he's not a witness yet. He hasn't come in. I don't think he's come up really at all other than passing and maybe the firm. So why don't we skip ahead to the next questions, and you could always come back to that if somehow he has made an issue in this case.
That's great, Judge. I needed some clarity because the state is objecting that it's not full and accurate. I'm keeping things out, and then they're objecting that I'm putting too much in. So I'm just trying to avoid every question having an objection, Judge. So on January 5th, 2024, we had a text exchange where we talked about that I had discovered that Nathan took Fani on a cruise and a trip and paid for it with the business card. You told me you were on a plane home from Dubai, but you would call me as soon as you got home. Do you remember that?
So what I have is a text message from you saying, "Oh my God, Nathan took Funny on a trip to Napa
Hmm?
and paid for it with his firm."
Okay, continue reading.
And you said, "Is he that dumb?"
Hmm.
And I said, "Wow, I'm on a plane from Dubai, land at 3. We'll call you as soon as I land."
So that is accurate. That's what you told me.
That I will call you as soon as I land, and wow.
Yes.
Yes, that is accurate.
And then you told me that you weren't surprised because they took many trips to Florida, Texas, and California.
Okay, so I don't have that, but, and I can show my phone, but I don't have that in my phone.
So the question is just, do you recall?
I do not
saying that,
recall.
Communicating that to me?
I do not recall.
All right.
Do you recall telling me that it was when she had to move her daughter a trip to California?
I do not recall that.
And Judge, may I approach the witness?
You may.
Thank you. In the packet I gave you.
Oh, I see it.
Take a look at that and see if that refreshes your memory.
Yes, I see this.
Okay. Does that look like, does it refresh your memory?
It does not. I mean, I see what's on the text chain, but you said this happened January 5th?
I can tell you exactly when it happened. Because there's no date and time stamp on that. Let's see. It was, let's see, it was. I believe it was January 5th, but just give me one.
Judge, I just want to, on behalf of Mr. Wade, just to review the objection again. We still don't.
To which question?
To the current question, we still don't know the source of this information, whether it was privileged or how he obtained any of this.
I'm wondering now if there's a timeliness issue on your objection since he already, well, he said he doesn't recall. So there's.
He just gave the date. He did.
Sure. Well, his question or his answer was he doesn't recall and his memory has not been refreshed. So I think it's time for the next question.
May I approach the witness, Judge?
Okay.
Can I see what you're
Oh, yeah.
approaching the witness with, please? So is this the complete text chain?
Yeah, it's the complete text chain. While they're looking at that, can I just ask you, did you delete any text messages?
I have several messages in the phone with you. I've never deleted. I mean, there are messages about family and my health and things like that. You asked me to be on some panel.
Yes.
And so I think it's complete, but
Well, no, my question was, did you delete?
no,
any
I
text?
haven't deleted anything. No,
Okay.
I have not.
And I offered them to look through my phone earlier if they are welcome to.
You never provided it to us.
I said you need.
Your physical
had it.
phone, you never provided it to us.
It's the
Alright.
only phone I have, Judge.
Yeah, I understand and I don't want to keep popping up, but my concern, of course, is that these exchanges are just two lawyers gossiping about information. And I'm concerned about it coming into the record
is a thing, but if we could do it in a way that the substance of this gossip is not, that part is not impeaching, the contact is impeaching. So
I don't think we've gotten to that point quite yet, Ms. Cross, but you can renew your objection if you think we have. So right now, the sole thing that Ms. Merchant is trying to do is hand him an object to refresh his recollection again. So we'll see where we get with that.
And I don't have any way to download it. He doesn't have an iPhone, so I don't know.
May I, one,
Mr. Zeta.
the court is a trier of fact. You're going to be able to determine whether something that has come in, if you choose to, is hearsay, whether it's admissible, whether it's relevant, whether it's impeachment. You're in a position that if it all comes in, but you reserve the right, or all parties reserve the right to object, we can deal with it. This is not a jury. We don't have to worry about the jury hearing something that it will no longer consider. All we're doing now, with all due respect, and I understand there's a process. The state doesn't want something to be heard.
I object to that.
They've repeatedly attempted to stop questioning. Your Honor can hear it all and then decide what is and is not relevant or admissible. We don't have to go through every single one of these. The only time you have to go through this is if it is in fact a communication and it's a privileged communication, and an argument has to be made at that point as to whether or not it should be elicited or it is subject to being stated in open court. Otherwise, all of this could come to the court and the court can then decide how it wants to treat it. That's
All right. I appreciate that, Mr. Sada, and I think it's certainly accurate that we could have an approach where if it's a close toss-up on an evidentiary question, we can have it all come in and sort it out later on the record. I don't think we've quite reached the point where I need to do that. I think we still have time to get into these, and it'd be my preference to keep the record as clean as possible and without questionable evidentiary issues. But we may get to that point. So the question from Ms. Merchant was to approach the witness and with an object to see if that would refresh his recollection to the last question asked.
Yes. Now, I'm sorry, the state scrolled through it, so not right there again. No, I mean, like, it was on the screen. Now I can't find it. So I'm going to move on to the next question that I actually can find, and then I'll find that and come back to it. I sent you a statement and said, upon information and belief, Willis and Wade met while both were serving as a magistrate judge and began a romantic relationship at that time. And you corrected me and say, no, it was in municipal court. Is that correct?
I think that's pretty accurate.
And is that based on your personal knowledge?
But what question, was it municipal court or when they first met, or?
My question was, is this accurate? Upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And you wrote, no, that it was municipal court.
Okay.
So I answer.
Mr. Bradley, just a second. Mr. Chopra has risen.
Sorry. Your Honor, I do have one purpose here, and that purpose has now been met. Any information that Mr. Bradley may possess would in fact have come from his representation of Mr. Wade. This falls within the purview of his divorce proceedings, which, as we've testified earlier, commenced in December of 2018. There is no pierce or shield associated with it, and so we would say that under Rule 1.6, we should not be compelled to give any further information.
Okay, and as we discussed about before the break, Ms. Chopra, if I ruled earlier this morning that this witness is going to be directed to respond to any question to the extent it falls outside of attorney-client privilege and only attorney-client privilege, meaning 1.6 is not going to bar his testimony in this case. What would be your response then?
Then Mr. Bradley would have to consistently assess on his own, unless I'm jumping up and objecting for him, whether or not this came within his knowledge based on his representation. And I can say, based on the phrasing of the question from Ms. Merchant, it would in fact come within information obtained from his partner client at the time associated with the activity in question.
All right, Mr. Evans, same issue.
I just want to reiterate that it's a compound question anyways, and so it needs to be separated out, but it's still based, we just renew the objection that it's still based on gossip, either gossip or privileged communication. He doesn't ever cite the source of where any of this information is coming from, so I just wanted to renew that objection.
Okay.
There you go.
Judge,
Merchant.
as far as privilege, any privilege objection, it's been waived, particularly for this issue because Mr. Wade
You did testify on this subject.
testified on this subject.
Well, he didn't testify as a communication with his attorney about any subject. He testified factually about what trips he took and events that occurred. He didn't testify, to my recollection, about any communication with his attorney.
But he testified about the subject matter of the question that was just asked, which was when apparently they first met.
Furthermore, Judge, my client wasn't privy to that testimony. We have been under subpoena and therefore under the rules, so we do not know what was or was not
Sure.
testified to. Everything he says would be a violation of that privilege unless we know specifically what all has been waived.
Sure, unless I make a finding that there was an express waiver on behalf of the client.
Yes.
Per
All right.
question.
Okay.
And
Sure, got it.
So
All
for
right.
this question, to ask that you find that there has been a waiver of the attorney-client privilege because Mr. Wade testified to something directly different than what this witness, we believe, has
Okay,
knowledge
Ms.
of.
Cross.
Yeah, so Mr. Wade testified as to when they met. That is not the entire substance of the text message that
And began a romantic relationship.
He did not testify that they
Okay.
were serving as magistrate judges when they began a romantic relationship.
All
He
right.
testified differently.
Okay, Ms. Merchant, I think you're going to need to establish whether this witness ever gained that knowledge independently or during the course of a attorney-client relationship.
Did you have any, thinking back to the source of your knowledge, and let me just, before I do that, let me remind you what is covered by attorney-client privilege. The communications that relate to matters in which legal advice is sought, and communications that have been maintained in confidence, and no exceptions to the privilege. So it's communications that are in furtherance of legal advice. Your knowledge that their affair began, that their romantic relationship, began while they were both serving as municipal court judges. Is that from your personal information, your personal knowledge, or is that from?
I'm going to overrule that objection, Mr. Chopra. He can answer that question.
State that question again.
Your knowledge,
Is any knowledge, if any,
if any knowledge, of Nathan Wade and Fani Willis's relationship, romantic relationship beginning while they were both serving as judges, is any knowledge that you have from your own personal knowledge or something that was told to you in furtherance of legal advice?
I have no personal knowledge of when it actually happened. I was not there. I do not have any personal knowledge, so
Okay.
I would choose not to answer that question under 1.6.
Mr. Bradley, we made a distinction earlier
Yes, sir.
that it's a bit narrower than that.
Okay.
1.6 is
I have no
encompassing.
personal knowledge, Judge. I apologize.
Okay.
If you
And
were,
that's not a problem. The issue is attorney-client privilege. And so whether what you learned, if anything, was during communications with a client.
It was.
Okay. Ms. Merchant.
and was it any knowledge that you had as to the truth of that statement, was it told to you in furtherance of legal advice?
I'm going to object to that. If that statement is true.
That's how I.
And the witness has already testified he has no personal knowledge about that. So whether he represented at one point it was true or not true, he has no personal knowledge about that. So could not testify.
Prior inconsistent statement, Judge. Do it all the time. That is what the state
It's
does
not a
regularly.
statement.
They bring in, if it's a prior inconsistent statement of another witness, Judge. Mr. Wade
Which other
testified.
witness?
I'm
Okay.
sorry.
Okay, Mr. Wade testified.
That this that their relationship did not start.
But you can't impeach him with a prior inconsistent pay statement that's privileged. And
No,
so
but
we're
it's-
still, we haven't gotten over the privilege hurdle.
The
You said-
privilege hurdle we've gotten over with fraud on this instance.
Well, that's the first time you used that word. So if you want to make the argument of why that applies, you can do that now.
Yes, Judge, the crime fraud exception, it applies because of the crime fraud exception.
Which crime and or fraud was committed here?
So there's a couple different things, and I want to just address them both because he's raised 1.6 and also raised attorney-client privilege. For the crime fraud exception says the privilege doesn't apply if it's if the existence of it, essentially if he has to keep something secret to allow a fraud upon the court to continue. So we've got that. We've also got
No, it has to, the legal communications have to have done in furtherance of a crime or fraud. How has that been established? And
Well-
what crime or fraud are we talking about?
we're talking about perjury, lying to the court.
In the affidavit filed last month.
Yes.
And so what have you done to link the communications that he made maybe, I don't know, years ago to the affidavit filed last month?
The communications he made years ago, it's proof of the affidavit being incorrect, being false. He's given
It may
a prior
be,
inconsistent
but the
statement.
legal communication has to be in furtherance of a crime or fraud.
Right, but he also can't protect. So, and I think it's more under.
So if he had no idea, an affidavit wasn't even going to need to be filed until a month ago. And these communications and everything happened well before that. How is anything that they communicated in furtherance of that affidavit that they didn't even know would have to be filed one day?
It's been waived. That part's been waived because he filed the affidavit. So you can't file something that's false and then your lawyer know that it's false and then say, oh, well, privilege, my lawyer can't correct that. When he waives the privilege, and he waived the privilege, he testified about this yesterday.
Okay, Ms. Cross.
I don't think that's even close to an accurate representation of what the law in this area is. And beyond the real kind of throwing out fraud and this and crimes, which what you have, Your Honor, is a conflict in the evidence at this point. I know which way the weight of the evidence appears to me, but that's going to be for the court to judge. A conflict in the evidence, that is not a crime. That is not a fraud. That is not perjury. That's a conflict in the evidence for the court to
So I agree with you there that you would have to first establish a crime or fraud occurred by preponderance. Got it. And anything else?
Just that she can't, under the guise of impeachment of this witness, number one, establish that. Number two, the witness has already said he doesn't have any personal knowledge of that. And there is the kind of specificity that is required to lay the predicate for a crime fraud exception to the attorney-client privilege is nowhere close to being met here.
Okay. Anyone else want to be heard? Mr. Seda.
Yes, this is what I sent to the court earlier. This is not crime fraud. The scenario in the case I said, do you want me to cite it for the record?
Go for it.
Owens Corning Fiberglass Corporation versus American Centennial Insurance Company et al. And it was 660 Northeast 2nd 812 out of the state of Ohio, Lucas County, Court of Common Pleas. And it references, make sure I get the right page. I think it's page 256. Point in the case for the holding of the statement. If be a party or a witness chooses to testify falsely, and our position is that Mr. Wade testified falsely when he claimed the relationship did not begin until 2022. That if there are attorney-client communications in which the same individual witness has told his attorney something contrary to that, inconsistent with that, here that the relationship, personal romantic relationship between Mr. Wade and Ms. Willis began prior to November 1st of 2021, which would be the day that he was hired. That if that communication took place, that is the attorney communication, that the fraud upon the court is Mr. Wade lying under oath about the starting date and the attorney-client privilege under those circumstances where that material fact is pierced and the attorney may be forced to testify to the contrary or inconsistent statement so that the fraud on the court no longer holds. In our situation, that is precisely what we are trying to do. If this witness's testimony, again, and the court may have to hear some of this ex parte in camera to determine, but if this witness is able to testify that Mr. Wade told him, under whatever the circumstances may be, that the relationship with Fani Willis began before November 1st of 2021, then we know from what the witness has testified to, Mr. Wade, that he lied under oath to the court. And that's a fraud upon the court, and the attorney-client communication that specific matter is pierced and needs to go into the record. Now, how best to do it? The only way to do that, if it's not in writing, and apparently it's not, is for the court to hear in camera, ex parte, what the communications were that are sought to be kept privileged. If the court deems that it is not inconsistent or contrary to what's testified, then you wouldn't pierce the privilege. If, on the other hand, this witness honestly, that is, now we're talking about Mr. Bradley, actually testifies to what he has told in text messages to Ms. Merchant on behalf of Mr. Roman, that he absolutely knows that the relationship started before November 1st of 2021, then he's testifying that his client took the stand and lied under oath and therefore did a fraud upon the court. So my request in this regard, what's going to have to hear from counsel and from counsel from Mr. Bradley and from Mr. Bradley to determine whether or not he actually said what he said to Ms. Merchant and whether or not it was based on communications, whenever it took place with Mr. Wood.
All right, Mr. Sato, I understand. Thank you for clarifying your argument there. So I understand this fraud upon the cart theory. And what I'd been going back and forth with Ms. Merchant on earlier was that, as I understood, crime fraud applied in Georgia was that the communications had to have been in furtherance of a crime. And to me, that presupposes the existence of a crime at the time, or the forming of one at the time of the communications. The theory you're putting forward is one where we go back in time and can reopen that box because it's now become relevant for something completely potentially unconnected to the communications whatsoever. Is that fair?
That falsity has occurred now
Right.
by the very person who is attempting to use the communications as a shield to
Sure.
protect his life.
Okay.
And when I say crime fraud, it's a fraud waiver that's what Millich calls it is essentially. I mean, Millich says that it doesn't offend the privilege to ask an attorney to testify to matters already freely discussed by the attorney and a client at another hearing or proceeding. Allowing a client to selectively waive and reassert the privilege as tactics dictates, suggests that the client is using the privilege as a sword and not merely a shield.
Sure. So I think it was quite explicit that Mr. Wade never waived anything regarding to communications between him and Mr. Bradley. He was willing to discuss the subject matter, but he was never willing to get into communications that occurred between him and Mr. Bradley. So as to Mr. Sadow's point of this fraud upon the court theory, my question is going to be, has that ever been applied in Georgia?
The answer to that is not appears to have been applied in Georgia. I cannot find a case in which it has been applied. The cases that I have, case that I gave you plus the cases cited in there are the only thing I've been able to locate. Although I think that the bar rules, if we want to go back to those, and I don't have them in front of me, that a lawyer should not allow his client to commit a fraud upon the court.
Okay.
And I think that, along with this, gives the court the discretion to do that. And the only way to make the record, even if the court suggests that this is the law that the court should apply, but even if the court disagrees, there's no way for there to be a record about it unless Your Honor does it ex parte in camera to determine the nature of the privilege, which of course Your Honor knows from earlier days is how judges can do it with the Fifth Amendment privilege. They can do it with any privilege, as long as it's ex parte in camera. So I'm asking the court to do it, because when I get up, I'm going to ask them directly. I'm not going to go through this that's going on now to find out whether or not Mr. Wade has ever told Mr. Bradley in his capacity as his attorney or otherwise that the relationship started earlier than what Mr. Wade testified to.
All right, understood. So the big takeaway I'm hearing from that, Mr. Sadow, is that once again, we're hearing the words a matter of first impression here. And noted. Mr. Gillen.
Yeah, very quickly, Your Honor. Number one, he apparently, now he's claiming a privilege, which he certainly did not assert when he was communicating in a text with this person.
Sure, but do we have any indication Mr. Wade waived it and allowed him to communicate by that text?
We know what he did. We know what he did.
So how's that an implied waiver?
I would assume that as the attorney, that he would know whether or not he should protect a communication.
That's a pretty big assumption, right?
Not all communications are protected, number one. Number two, let's not forget how we started on this journey with the state getting up and making very serious allegations against Ms. Virgin. Asking for sanctions, saying all of her representations were inaccurate. And now they are doing whatever they can to block access to that information, which shows exactly what she said was exactly the truth. What they're trying to do is they're trying to say to the court, the 100% accuracy of Mr. Wade's declaration and of his testimony. And by the way, please, Judge, don't let Mr. Bradley tell you what he knows, because what he knows is that this relationship, based upon what we see from the text and what we've seen in the context, would show that the relationship started before November 2021. So I think we have a waiver issue, and parenthetically on the issue of crime fraud, Your Honor. The issue about crime fraud is whether or not in any context the communication would be not in furtherance of a crime at that time, but it could be for any particular crime committed by the client in the future as well. It doesn't have to be something that's being committed at the time. I will also note that when you look at the attorney-client privilege, the law basically says, look, this is a privilege which blocks evidence from coming in. And so in order to have that, they have the crime fraud exception, which is a very low standard once a prima facie showing has been made, which I believe has been done by Ms. Virgin.
All right, let me clarify one thing, Mr. Bradley. When you testify to personal knowledge, does that include anything you may have seen, heard, outside of communications with a client? When you say you lack personal knowledge, does that include anything you may have seen or heard outside of communications with a client? And you can tell me if that question is horribly phrased. You lack any personal knowledge?
Yes, sir.
Mean that and include anything you may have seen or heard outside of communications?
Outside of communications with my client.
Mhm.
That's correct.
Okay. And communications that were made, if any, that relate to the subject that you were asked to, were there any other third parties present that may have resulted in a waiver of privilege?
Including texts.
Am I answering your question or her question? Okay.
Are there any other third parties ever present with you and a client that would have resulted in a waiver of these privileges?
No, Judge. I can't recall anybody being present. I mean, we ran an office, we had people around our office, but no, I can't say that there were other people present.
All right. And did you ever receive any kind of a waiver from your client at any point?
I have not received a waiver.
And anything that you learned regarding the subject matter at all, if anything, was it in the course of legal advice, of receiving or giving legal advice?
That's a broad question, Judge, to answer, because the advice was given. And then you have interaction. I mean, it wasn't, hey, this is for, to say specifically, this was for that, or, I can't sit here and say that. So I don't know how to answer that question, Judge.
All right. So
I was given a case that may reflect the same proposition I was arguing from. It's older case. It's Atlanta Coca-Cola Bottling Company versus Goss, Goss. 50 Georgia Appeals 637 appears to be a 1935 decision. Have not had the benefit of shepherdizing it, so can't say certain that's been limited or overruled. It looks like it's maybe head note number 2, at least the one I'm looking at on the computer. Language is in the case, okay, is as to violation of the law or commission of fraud, protection extends only to communication after the act or transaction is finished. It does not cover communications respecting proposed infractions of the law and the commission of a crime or perpetration of a fraud. And then it cites some cases. And then it goes, the privileged communication may be a shield of defense as to crimes already committed, but it cannot be used as a sword or weapon of offense to enable persons to carry out contemplated crimes against societies, frauds, or perjuries. So our position, as I indicated before, is the witness, Mr. Wade, has committed perjury on the witness stand and called into question the statement.
all right, understood, Mr. State. Mr. McDougall.
Your Honor, this is adjacent Georgia law, perhaps not controlling, and I'll explain that in just a second. And that's Rule of Professional Conduct 3.3 A2. A lawyer shall not knowingly fail to disclose a material fact to a tribunal when disclosure is necessary to avoid assisting a criminal or fraudulent act by the client. A4. Now, the reason I would qualify that, and since we're talking about candidate of the court, I need to do that. I believe this rule is regarding the conduct of advocates representing clients in court. It might not govern or control the situation where the lawyer has been put on the stand, but it's adjacent to the point Mr. Sadow made earlier.
All right, fair point. Okay, Ms. Troper, anything you want to address on that?
Briefly, Judge, and clearly there's a lot of smarts in this room, but this whole thing is a deductive fallacy. It is suggested that the truth of the conclusion of the argument necessarily follows from the truth of the premises given, when in fact the conclusion does not necessarily follow the premises. We've called him a perjurist. He is officially succeeded in saying the thing itself is true. Therefore, we must ask these other questions. And Judge, it's a fallacy. It does not exist as such, and the privilege should still apply.
All right. Thank you all. So I think here is what we need to do, as I understand the law. As I find it, the crime fraud exception only applies when by preponderance we found that communications made in the existence of a relationship were in furtherance of a crime, or the client at the time knew or reasonably should have known that a crime, that the attorney was being used to further a crime. I don't think that's been established here. Maybe something happened afterwards, and that's something that can be argued during closings, essentially. So I don't think the crime fraud exception covers this. The objection is preserved for the record. Mr. Bradley has indicated also that anything he learned about this subject occurred during those communications. There's some uncertainty on that point. And so in order to preserve the record, at the conclusion of the hearing, I think I can go in camera with Mr. Chopra and Mr. Bradley, and we can put in a sealed filing exactly what the extent of those communications were, if any were relevant. Or excuse me, not relevant, but just what they were, and those would remain sealed and until some time if we're ever directed otherwise. However, at this point, the question, getting back to the question asked by Ms. Merchant, as asked, would be sustained on the issue of privilege, the premise. He may have told you something, but it does not appear that there's any evidence that the client ever waived and allowed that information to be conveyed to you. Next question.
Thank you, Judge. All right, let's see. So, we talked about Ms. Willis and Mr. Wade coming to and from your office and security details following them. Do you recall that?
Do I need to look at my phone?
No.
Or can I?
I'm just asking if you
Oh,
recall.
do I recall? I think I did, yes.
Do you recall security taking Ms. Willis to your office?
I object to that.
Does he recall
Actually, I
Ms.
take that
Willis
back. No,
taking?
I don't object.
You can answer the question, sir.
I do recall security detail bringing Miss Willis to my office.
Do you recall approximately when that was?
I do not.
And was that on more than one occasion?
I remember 2 occasions.
Okay.
Yes.
Can you tell me about those?
I can't remember when they were.
Were they before she became DA?
So I don't know if she had security detail before she became DA. So, I mean, if she was sworn in, or I don't remember the dates, but I do remember. I think she was DA.
Maybe during her transition team period? Was that?
No, it wasn't. Trying to remember. She would have had to have been the DA, I think. And I don't want to go on, I think. But I do remember twice her coming to our office, correct?
And she had a security team both of those times.
That was yes, she has a security team with her.
And do you believe that it's a different security team than she has now?
I don't know her security team now.
Well,
However,
I'm sorry.
I don't know her security team now. I don't know her security team now.
Do you remember telling me that it changed at some point, her security team?
Yes, I think I recall saying that, yes.
And that the most likely people that could testify or had seen things about them having a romantic relationship early on would be the original security team.
I don't recall saying that, no, but
Do you recall talking to me about other people that might have known about their romantic relationship?
I recall.
Yeah, I mean, objection based on, we don't know the source. I mean, this is either based on privileged information or it's hearsay. Either one.
It's neither. I asked if you recall.
You need to clarify it. If you're actually going to think, if you think that this draws on information from outside the relationship that he's already testified to, then you need to lay that foundation. Sustained.
Are you aware of other people that you believed would have known about when their relationship began?
I object to the relevance of that. Again, the witness has testified he has no firsthand information of it. Anything he knows about the topic came from representation. Who he thinks might have been able to say something else is speculation, not relevant to anything, and a backdoor to get in the gossip and innuendo that has been pretty much this entire.
All right. Okay, Ms. Merchant, I think we're getting to the point where, you know, the reason I thought this line of questioning was appropriate was to rebut certain inferences about why we were here in the first place.
Right.
But to go into it at the granular level, I'm not as wild about. So if maybe you can ask more overarching questions, and if you have anything else you think that's relevant, then you can get to those as well.
isn't it true that I gave you a copy of the in this case? I emailed it to you and you read it, reviewed it, and emailed me back that everything in it was accurate, to your knowledge.
You emailed me and you,
Objection.
Okay. All right. So there are things contained within that, Ms. Merchant, which he has now said fell within the privilege and that he did not have the ability to waive.
Okay.
So I think that's where we have to leave it there.
And I believe I still have to ask the questions, and then if he wants to assert the privilege, I think.
Well,
to
I
preserve the
think he's
record.
pretty much already established the privilege and the objection has been made, and I think it's a valid one at this point based on the record. So the answer was he did acknowledge that you sent him the motion, and I think we leave it at that.
Let's see. And you had knowledge about an apartment, and I'm not asking what Mr. Wade told you in furtherance of legal advice, but you had knowledge about an apartment in East Point or a condo in East Point that was owned by someone and Miss Willis was staying there.
Judge, privilege.
I think in the way the question's phrased, she qualified that. So
I did not have knowledge.
You did not have knowledge.
I did not have personal knowledge at all. No,
So no knowledge outside of what is privileged.
that's correct.
Did you have texts between yourself, Miss Willis, and Mr. Wade?
Why?
Have you ever?
I have. Maybe once or twice, but
Did Mr. Wade ever ask to use your credit card to pay for trips?
Objection
on
on privilege. I mean, just the whole same thing.
just asking him to use a credit card, how's that in the nature of furthering a divorce proceeding?
Do we try to-
All right.
I had a business card and we would use my business card. The firm would use my business card.
For travel?
Are you asking if I use my business card for travel?
Would Mr. Wade use your business card for travel?
I recall, I recall a trip, but I don't know if that trip has anything to do with this case. So I do recall him using my card once.
When was that?
I don't even know when that was, and that's the honest truth. I recall him using my card once, but I cannot remember what that was for. I do remember it was a trip, but I cannot accurately state, where it was and who it was with or anything like that.
And he paid you back for that trip in cash?
I can't remember how he paid. I think it was. I mean, I'm not certain if it was cash or a check. We routinely would use my card for filings, for paper, for whatever stuff with the office. And so,
Oh, I'm sorry. You're done. Sorry.
and so he would, whether he paid me back in cash or whether he wrote a check, it was paid back to the business card.
But this was the only time he had used it for travel.
I cannot recall. I don't even have a business card anymore. But I do recall at least once for travel. Yes.
And that was when you were still law partners with him, though, correct?
That is correct.
Do you recall approximately when that was?
I do not.
You did not go on that travel with him, though, correct?
I did not.
Okay. And so he asked you to use your card for the travel.
Yes, I mean, I'm assuming, I mean, we would use the card for firm stuff. And so it was a business card.
Your business card, though.
It was my business card, yes.
Right.
The law office of Terrence A. Bradley, correct.
So it showed up on your accounts.
That is correct.
Okay. Wouldn't show up on his accounts, though, correct?
That would be accurate, yes.
Do you know if this was before he became special DA in this case, special prosecutor?
I cannot recall.
Did you see he and Miss Willis together? You said you were in and out of the office, in and out of the DA's office. You saw them together, correct?
In and out of my office or the DA's office?
The DA's office.
Correct.
They're in and out of the DA's office.
Did I see them in and out?
Yes.
Well, if you preface it like that, no. I saw him in and out of the office when I would be there doing my filter work for the taint team.
Right.
He would come by. I rarely saw Miss Willis and Mr. Wade together in the DA's office.
You brought up the taint team. Let's talk about that for a minute. Tell me about, you did work you had a contract as a taint lawyer, correct?
That is correct.
Okay. And that was in the anti-corruption unit?
Yes, I think so. Yes, correct.
And how did you get that contract?
What do you mean? How did I get it?
How did you get the contract?
It was, oh no, it was proposed,
By who?
we were, it was proposed by, I guess it came from the district attorney. I mean, I didn't speak directly with her.
Okay.
It was, with Mr. Wade, and he asked if we would be interested, in having a contract with the Fulton County.
Okay.
And I said I would.
Mr. Campbell?
I think so. I mean, I can't recall if he asked us both together or not. Rarely, we all handled several, different things for the firm, criminal, personal injury, things like that, family law. And so rarely were we together there at the same time, like for an abundance of time. So he may have called me and then he may have called Chris. I can't recall how we got the contract, but
Was Mr. Wade, to your knowledge, part of the transition team for Miss Willis?
to my knowledge, he was a part of the transition team.
Did he spend a lot of time at that office during this transition period?
He did.
So from when Miss Willis took office to when you left the firm, did Mr. Wade spend most of his time at the DA's office?
You said most of his time, are you saying just working business hours or?
Working business hours.
I would say he spent, I would probably say he spent majority of time. If you say over 51%, I would say yes, he spent over 51% of his time.
And that was the entire time from when she took office to when you left the firm.
I can't say that that was the entire time, but yes, it was majority of, it was I can't pinpoint specifically when the time that he would spend. I think, if my memory serves correctly, getting to the majority of the time, it would have been, whenever he started with this, maybe. That was
As a special prosecutor?
when you say majority of the time.
Right. Okay, so let's talk about the time before he became special prosecutor. Did he spend a lot of time at the DA's office then?
He spent time. I mean, depends on what you say is a lot. He spent time at the DA's office, correct?
And so just so we're clear, you were hired first on January 25th. Both you and Mr. Campbell were law partners and you were both hired by the DA January 25th, 2021. Is that correct?
Repeat the question, I'm sorry.
You and Mr. Campbell
Yes.
both were hired
Mhm.
on a contract basis by DA Willis,
Mhm.
January 25th, 2021, correct?
Which contract are you talking
The
about?
first one, the taint contract, not the first appearance contract, the taint
Okay.
contract.
Well, you said the first one, and the tank contract wasn't the first contract, and so,
Okay, so what was the first contract?
to my knowledge, the first contract was the first appearance.
Okay, so let me just mark these. Let's see, what number are we at? 23, 24, 25. Those are his contracts. Oh, sorry. Judge, when they're done reviewing contracts, thanks. Thanks. Mr. Bradley, showing you what's good mark. Defense exhibit 23, 24, and 25. If you could just take a look at those.
Okay, I see.
So on now that you've reviewed those, is it true that on January 25th, 2021, you got your first contract as a taint lawyer?
As a taint lawyer, yes, I see the date on that as a taint lawyer, but I'm also looking at this contract here for first appearance, and there must have been, I don't have it before me, but there must have been a contract before this.
Okay, so you think there's a fourth contract?
I can't say that there is or isn't. What I do know is that we did first appearance during COVID, and it was before 2021. So I don't know, um, if I had a contract, a written contract at that particular time or anything, but I do know, I think that you could look at the recordings because everything was recorded at that time, as to when the first appearance contract started and the taint contract started.
So when the three of you were partners, you had at least two contracts to do taint work, which is filter work, and then at least two contracts to do first appearance work, pretty much throughout that entire 2 years, right?
Well, it renewed. So, I mean, it just renewed. So yes, I mean, if it was the same contract, but it was a renewal of the contract.
So how did you, and you said you got these contracts through, Ms. Willis gave them to you, but it was through her knowing Mr. Wade, correct?
Yes, I didn't have a meeting with Miss Willis or anything. It was it was brought to the attention that a contract was going to be needed or awarded. And if I was interested, because this was off of mine, and I said yes. And so
And so Mr. Wade brought that to your attention?
he asked if I was interested in doing the contract, correct. And then after that is when Ms. Willis, would come in, or I think we actually came down here or something, and signed the contract.
And so that is how you were paid from Fulton County, these contracts.
From Fulton County government? Yes, ma'am.
And you shared your partnership, you shared a third of all your profits with Mr. Wade.
At that time, yes.
And so his contracts, he got a contract that same year, 2021, and he shared a third of all his profits with you, correct?
Yes, that should be fairly accurate.
Okay. So during 2021, 2022, you all had 2 filter taint contracts. You had 2 first appearance contracts, and you had Mr. Wade's special counsel contracts, correct?
My firm had what I have here,
Okay.
correct?
But Mr. Campbell and Mr. Wade were part of your firm, correct?
So I don't think at this time we had established WBC.
Okay.
At this time, I think I had mine, Chris had his, Nathan had his, and we operated in the same building. But if you ask me, did we fee share or, without everything that came in, yes, that is correct.
So you weren't actually partners, you just fee shared.
At this time, well, yes, at this time, we were not. If we were at this time, I had Law Officer Terrence Bradley, Chris Campbell, PC, and whatever Nathan's was, if I'm not mistaken. I'm just.
And all these the taint contracts and the Nathan special counsel contracts, all of those were under the anti-corruption unit, correct? You can look.
First appearance was not under that. The tank contract, if I recall, was under the. I don't think they called it. What are you calling it?
You can take a look at your contract if you need.
Okay.
And I'm not asking about the first appearance. I'm asking about the taint contracts
Mhm.
and then Mr. Wade's contract, which has already been admitted in evidence. If you need to look at that. Let me know when you're done reviewing.
Well, I see on the first page where it says taint attorney, and I'm trying to go through and I see where it continues says taint attorney, but it always says Fulton County District Attorney's Office. Your question was specific as to the anti-corruption unit, and I'm looking for the verbiage of anti-corruption unit, so I apologize.
Oh, no, take your time.
And see, on both pages, I mean, it starts out Fulton County District Attorney's Office, and then it just goes to initials FCDA, unless I'm overlooking where it says the anti-corruption unit, then the contract was with the FCDA. I mean, unless you want to show me something.
I'm just asking you, and I didn't know if that would refresh your memory. Those contracts were for the anti-corruption unit, right?
Well, they were for the district attorney.
For.
I work for the DA.
Okay.
I work for the DA.
Okay. So just in general, the DA.
Correct. I work for Fulton County District attorney's office in a as a contract person, as it says here.
And when you did the taint work, you had to report to Sonia Allen?
I did not.
You did not. Who did you report to then?
I can't remember his name. His first name was Brian.
Okay. And let's see. So I know you said you met with Miss Willis when you signed those contracts, right?
Yes, I know I met at least one time to sign these contracts, or to sign when I signed the contracts, yes.
Did you meet with her any other times?
I did not personally meet with Ms. Willis any other time. When you say meet with, what do you mean meet with?
Talk with her, meet with her.
I mean, I would see Ms. Willis in passing if I'm walking through the office and something like that. But no, I didn't have any meetings with Ms. Willis.
Okay, so the only times you met with her were when you signed those contracts.
Clarify meet with. I mean,
Sat down and had a conversation with her.
I signed these contracts. So when I signed these, I met with her. To say that I sat down and spoke with Ms. Willis, are you saying in life, and you saying during this time? What are you asking me?
I mean, if it's voluminous, I can narrow down the times, but I wasn't. in
Ms.
the-
Merchant, I haven't really heard a point in a while. Can we get along to something,
Yes,
or we're gonna have to wrap it up?
So I had one more question about your texts. Have you ever been in any group text with anybody other than, with me and somebody other than Mr. Chopra and Mr. Merchant?
You gotta narrow that down. I'm sure you sent many
I can look
texts
at
over
my
the course of
phone,
his
but
So
life.
with him, if there had been any other texts? And I think that the state had some
Him-
things
him
in rebuttal they
being-
mentioned, so I was just trying to clean that up before it got there.
Can you try the question one more time for me?
Yeah. Isn't it true that the only texts that you and I have ever had have been between me, you and Mr. Chopra, or me, you and John Merchant, correct?
Can I look at my phone?
Sure.
And what's the relevance of that, Ms. Merchant?
They've said multiple times that there's this third party that we've talked to, and I'm trying to establish there's no third party. And I don't know why it was relevant, but the state's argued it, so.
Well, if Ms. Merchant doesn't know why it's relevant, then maybe it might
Okay.
become relevant later, but right now.
Ms. Merchant, I think you've been able to show
Okay.
what maybe launched this and answer the state's initial claims. And so let's get back to the core of what we were here for this hearing. Do you have anything else relevant to ask this witness?
Yes, just a few more questions. After it became known that you were placed under subpoena, did you get a call from Gabe Banks?
I did.
And was he trying to determine if you were going to be giving information in this case?
I don't know what he was trying to determine. He stated that it was an odd, I had not spoken to Gabe in a while. We are colleagues, we are friends, we are in the same fraternity, Gabe and I. And when he called, it was out of the blue. But he did call, yes, ma'am.
Okay. And you relayed that to me as well, correct?
I did.
And then you also got a call from your best friend who was relaying a message to you from Mr. Wade, correct?
No, I got a call saying that he got a call, not that a message that was supposed to be relayed to me. The call was,
I'm going to check if there's a hearsay. If the response will call for hearsay, thus far it hasn't, but
Sure. So here's the objection as to the contents of the call, Ms. Merchant.
I believe the contents of the call were to remember your privilege. I took that as a threat. I think Mr. Bradley took it as a threat, and I think he would testify to that.
And
hasn't testified to it. And he also said there wasn't any message relayed by Mr. Wade or any other party.
well, no, he didn't say it was by any party.
Mr. Wade.
So assuming he did hear something from a party, what's the hearsay exception for that, Ms. Merchant?
I believe that it was a threat, so it's a statement against interest. I'm sorry, it's a, if he took it as a threat to influence his testimony, then it's not hearsay, then it would be admissible.
All right, so
I did not take it as a threat.
if you're saying it's to the effect on the listener, perhaps,
Yes.
then we'll go from there.
Were you told to remember your privilege?
Your Honor, the witness just testified he didn't take it as a threat.
Understood. I'll overrule the objection and the testimony given the weight it deserves.
Can you repeat the question?
Were you told to remember your
Your
privilege?
Honor, can we?
I was not.
The witness, there may be a potential witness now in the courtroom because the person that Ms. Merchant is referring to is sitting in the courtroom.
Well, if that witness hasn't been told to testify, then I don't see any sequestration issues.
I don't know who it is. I don't know his
All
name.
right. Okay, and so were you told anything to that effect, Mr. Bradley?
Repeat the question one more time, but so I was not told, remember my privilege.
Something about privilege, remembering that.
I do recall privilege being mentioned, but it wasn't remember your privilege or, you know, a threat of any sort.
But you immediately called me after.
No, I called someone else after.
You called me quickly thereafter then.
I talked to you that day. Yes, ma'am.
Okay, thank you.
Let's sit down.
Your Honor, because this is a defense witness, is it the state's first cross? That's how we had been doing it yesterday.
No, actually, we're doing it just this way.
Yeah, I've been, this
Okay,
is
I
the first
apologize.
time he's gone, and then we go through all the defense, and then you'll have your chance.
Some foundation questions to begin with, please. Your testimony as you began representing Mr. Wade as his attorney on what date or what approximate date?
I didn't have an approximate date.
Then give me an approximate date when you began acting as Mr. Wade's attorney.
I would say it was, you know, if I'm speculating.
I really don't want you to speculate. I mean, you're the one that was the attorney and Mr. Wade was the client.
Right.
So give us the ballpark figure of when it was that you began acting as his attorney.
Maybe 2017, 2018, I think, maybe.
And the purpose for which you were retained?
His divorce.
So, according to you, from that time period, your communications with Mr. Wade with regard to the divorce or any matters related to the divorce, it's your position are confidential, I'm sorry, are privileged, correct?
Yes. Yes.
Okay, good. Now, did you ever meet with Ms. Willis and Mr. Wade prior to, and everything I'm asking you was prior to November of 2021, okay?
Okay.
Keep that in mind. That's,
Why are you yelling?
I don't think he's yelling, Mr. Bradley. He's just speaking up. All right, Mr. Sadow, let's go.
thank you. Prior to Mr. Wade getting his contract with Fulton County, which was November 1st of 2021, okay? Just please keep that in mind.
November 1st of 2021.
Right. Did you ever socialize with Mr. Wade and Ms. Willis prior to November 1st of 2021?
I've never socialized with Mr. Wade or Ms. Willis in any setting. If you're asking, have I ever met with them, then I would say yes. But when you say socialize, what do you mean socialize?
Have you ever gone out to eat with both of them?
Before 2021, I do not
Or
think.
November 1st of 2021?
out to eat with both of them before. When was she sworn in? I'm sorry. When was she sworn in? There was a dinner. There was a dinner before. When she was sworn in that I attended. Shaquille O'Neal was there, so it was like her inauguration dinner. So I'm thinking that's before 2021. So I would say yes.
Assume for purposes of my question, that
Yes, sir.
that's in early January of 2021.
Oh, that is early January 2021. Then, so yes, it would be before November. So if it was January, yes, that dinner would have been in, I'm assuming January.
Okay. And any other time that you socialized, went out to eat, went to anyone's home, you know what socialized is.
Exactly. So no, I did not socialize with Mr. Willis. With Miss Willis and Mr. Wade.
So prior to November 1st of 2021, did Miss Willis come to your offices? Your offices, the offices that you shared with Mr. Wade.
I think she came once or twice to our office, correct?
And the purpose for which she came?
I don't know. We had separate offices. I do recall,
Well,
I do recall some type of meeting happening at our office, and I don't know what that was about. I wasn't a part of those meetings. There was a meeting. There were other people there. There were other people from I want to say DA's office there, maybe.
Okay, let's go back to the basics. Miss Willis came to your offices, together offices, on a couple different occasions.
I recall Miss Willis coming to my office at least twice.
And on at least one of those occasions, or you tell us, did Miss Willis meet privately with Mr. Wade in his office that you observed or heard?
I can't recall.
You can't recall.
No.
Did she ever meet with you in your office? Miss Willis now.
Privately in my office? No. I've never met privately in any office with her outside of signing this contract.
Did Mr. Wade, prior to November 1st of 2021, ever talk to you about socializing with Miss Willis?
I can't recall.
You can't recall?
You're asking me if he ever mentioned to me that he socialized.
With Miss Willis, correct.
And I'm saying I cannot recall if he socialized with Miss Will, if he ever mentioned to me that he socialized.
Did he ever mention to you that he ate or went out to dinner with Miss Willis? Again, time period before November 1st of 2021.
Did he, repeat your question?
Did Mr. Wade ever tell you prior to November 1st of 2021 that he had socialized, gone out to eat, visited Miss Willis in anything other than a professional setting?
I'm sure he did, maybe. I don't recall any specifics of any dinners, any specific places. It's been 3 years ago, the time frame, but I do not recall at this time whether or not he ever mentioned any dinners or socializing.
Did Mr. Wade mention to you that he visited Miss Willis at Miss Willis's then current abode, which would have been a place, not her original house, but a place she was staying in the period of 2021 before November 1 of 2021? That is, the question is, did Mr. Wade ever tell you that he visited Miss Willis at her house?
I don't think I can answer that.
Yeah, privilege, based on communication by clients.
All right.
subject by case.
Mr. Sada, if you want to try and rephrase the question, you can, but otherwise that would be sustained.
On both grounds or just on the privilege ground?
Just, I didn't hear a second ground. What-
There was a hearsay ground.
Oh, that would be on privilege alone.
Did you talk to Mr. Wade at all about his relationship with Miss Willis prior to November 1st of 2021?
I think he's just laying a record, Mr. Wade. It's okay. And so on those same grounds, Mr. Sadao, on all subsequent grounds, apparently the relationship with Miss Willis in any way is covered by privilege according to this witness.
Well, I think the key words, respectfully, Your Honor, are according to this witness. So I'm trying to drill down to see if there are communications that are not within the privilege.
Sure.
I can,
So then we need to acknowledge the privilege in the form of your question, right?
you're asking me to ask it as in a way saying, are there any non-privileged?
Essentially.
Okay. Did you ever communicate with Mr. Wade prior to November 1st of 2021 about Miss Willis that was not privileged?
I mean, we discussed this contract, but
This contract doesn't help. You have to give me a
um,
exhibit number, please.
you said before November 2021?
Yeah, November 1st of 2021.
Before November, this contract for 1/25/21 is before that. So, I mean, we discussed this contract.
And if I remember
This-
correctly, when again, just give me that exhibit number so we can reference.
Exhibit 23
Okay, hold
would
on
have
one
been,
second. One second. On exhibit 23, did I understand you to say that it was Mr. Wade that effect brought you and Miss Willis together for the contract?
that would be accurate, yes.
Okay. And what did you understand was a relationship at that point between Miss Willis and Mr. Wade for Mr. Wade to be able to bring you to Miss Willis for the contract? It's not a hard question. It's
No,
a really
I'm
simple
just,
one.
state that again?
Mr. Wade is the one that basically says to you, go see Miss Willis about this contract, right?
Mhm.
That's a yes, correct?
That, Mr. Yes,
So
I
Mr. Wade
apologize.
had to have some knowledge, you would assume,
yes.
right? That you going to Miss Willis might bring you the contract.
I
right?
never went to Miss Willis. So I stated I never went to Miss Willis. I was told about that there was a potential contract, and that I was asked by Mr. Wade if I would be interested in doing that contract.
My
I never,
Okay, my question to you is, what was the basis that you understood Mr. Wade being able to potentially offer you that contract on Miss Willis's behalf?
I object to that. That's a mischaracterization. Mr. Wade offered it to him. I think he said he expressed interest. And also, I don't see the relevance of this at all.
So just in terms of relevance or phrasing, I'll overrule on those grounds. So the question is standing unobjected to, Mr. Bradley.
can you repeat the question?
You've explained to us how the contract
Yes,
came to you, correct?
yes.
And my question is, what was your understanding of the relationship of Mr. Wade and Miss Willis for it to have been offered, or whatever word you want to use, for him to have said, expressed to you whether you had an interest in the contract?
Privilege.
All right, Mr. Evans has invoked privilege on that question. So Mr. Sadao, I think you need to clarify whether,
Was it a privileged conversation that you had with Mr. Wade that let you know about the contract?
or, is the relationship was the question you're focused on.
Is the nature, no, I'm trying to do it in such a way, and I understand what the court's saying. Was the relationship that I asked you about just now between Mr. Wade and Miss Willis that gave rise to the contract? Did you know about that relationship as a result of an attorney-client communication?
No, I knew of that through whatever work they did together as municipal court judges. That's
And how did you know that? Who told you about the work that they did together as municipal court judges?
Mr. Wade told me that they did work at some conference.
Okay, now, this would have been something that Mr. Wade said, according to your time period, at the time that you were representing Mr. Wade, correct?
Say that again? Ask that again?
Mr. Wade would have told you what you just told the court after you had established an attorney-client relationship with Mr. Wade, correct?
Yes, but when he told me of them being at a conference, I mean, I'm not understanding how relate. I'm trying to understand your question.
Well, my question is basically, you had communications with Mr. Wade directly that were
Yes.
not attorney-client privilege, right?
I've had conversations with Mr. Wade that were not attorney-client privileged, yes.
That involved Ms. Willis, correct?
I just stated that they were at a conference. I don't know whether or not that involved her or not.
Well, if he's talking about her, that is, if Mr. Wade is telling you about Ms. Willis and Mr. Wade having met at a conference, right? Then he's talking about Ms. Willis, correct?
Yes, but he also told me about other people that he met at the conference.
But he told you about Ms. Willis as well, correct?
I think so, yes.
So there were communications in which Ms. Willis was at least a topic that was not covered by attorney-client privilege, correct?
This particular instance, I was told about a conference, and
When were you told this?
I can't remember the dates of the conference, but it would have been after the conference.
Okay, I'm trying to get just the time period here. After the conference, I want you to understand from the record, I believe we've shown that the conference was sometime in October of 2019.
Okay.
So could you give us an idea, that being a fact, when you would have had this communication about meeting with Ms. Willis at that is, Mr. Wade meeting Ms. Willis at the conference?
If that's the conference that they were at, yes, then, I don't know how many municipal court conferences there are. I do know that at the time that I was in the firm, Mr. Wade was, he had some position with the municipal court.
Yeah, right now, my only question is time-wise, assuming it's October of 2019, when do you tend to remember? What's your best recollection of when Mr. Wade told you about?
I can't remember because I didn't even remember that it was October 2019 until you said that.
So you don't have a present recollection?
I do not remember that, no.
Had to be before the contract, though, in January of 2021, correct?
That they met?
No, that you were told about Mr. Wade and Ms. Willis meeting at the conference had to be before.
Oh, yeah, yes, it would have been before that, yes.
So what other communications did you have with Mr. Wade about Ms. Willis that are not privileged? We know of one, about the meeting at the conference. Are you suggesting that that's the only one you ever had about Ms. Willis that isn't?
I cannot recall any. I cannot recall.
You cannot recall whether there were any other communications that weren't privileged?
No.
Well, I'll be specific, and I understand there's probably going to be objections, but I want the record to reflect. Did you have a conversation with Mr. Wade prior to November 1st of 2021 about Mr. Wade dating Ms. Willis?
Mr. Wade has risen. An objection is sustained for the record. Excuse me, Mr. Evans.
Say that again?
You don't have to answer the question, Mr. Bradley. Next question, Mr. Stay down.
Well, I understand it's been objected to and the court has sustained the objection. Can you tell us the circumstances in which, that is, under which Mr. Wade may have told you about dating? What I want to do is try to figure out if we can, you tell me if you want me, if I can do this. I'd like to know how the communications themselves took place, where they took place, how they took place, under what circumstance, whether he was at the time providing advice or seeking advice.
Mhm.
So those are the basics. If I can ask as to all those, but if
Sure.
the court's going to sustain the objection to those, then I don't want to waste your time.
And that's something I'll cover in camera. So I'll note the question and your question for the record, and I'll sustain the privilege objection to that. and
Okay,
cover
all
that.
of this prior to November 1st, 2021. Okay? I'm going to show you two text messages. I don't have hard copy of anything. This is,
Text messages?
this is,
No.
this is, you can see the date.
Where, yeah, what is the date of that one? Yeah, this is-
Just a minute. This is the first one.
That date is. What do you
This is
What you?
present. These are text messages between.
Okay, you want to get into the content of,
I'm going to set up a question based on it. Yes. And then here's the follow-up. You can see the date is still.
okay, so I'm going to have objections
Of
to
course, you're
that.
going to have objections. I realize that. I want to be able to show it to him, and then I'm going to frame the appropriate question, and then you're going to object. We'll see where we are. May I approach?
You may, sir.
You'll look at this text message. This part.
All right, look, can I read it first?
Of course, of course. Good.
Mhm.
Okay. And then this is the second one. It follows right behind it.
That's it.
Okay. Kind of hard to object. That's a question.
I know. Not know it's coming.
Okay. Then you must be a CSAyer. Mr. Bradley, I showed you two text messages, correct? Both of those text messages occurred on January the 5th of 2024 at approximately 11:56 a.m. Am I correct?
I think, yes,
Okay. And the text messages would have been between you and Miss Merchant, correct?
I didn't see it. Yes, it should be.
Okay. And I've shown the same two to prosecution, so we're talking about the same two. In the text message to Miss Merchant, you indicated knowledge of some activity on the part of Mr. Wade, correct?
I'm going to
I haven't asked him anything about what the,
flag for the court that this is a topic and a specific exchange that Ms. Merchant went into, and there were objections that were sustained.
All right, understood.
Yes,
and it's your testimony that the information that you imparted to Miss Merchant in these two text messages is based entirely on confidential communications between you and Mr. Wade, correct?
Objection. He's referencing specific knowledge. The specific knowledge comes from Mr. Wade, which is we've already established the privilege.
Well, the question, he didn't get into anything. He just said, are these two text messages about privileged communications? We haven't actually, I don't see an issue there. Mr.
yes,
Bradley.
And is it your testimony that the knowledge that you had, which you imparted in these two text messages, came from Mr. Wade and Mr. Wade alone? Is that
yes,
correct?
yes,
Can you tell us when it was that Mr. Wade imparted this information to you?
Objection.
All right, and I think
That's that's what you're going to do. And
sure. So I'll sustain that on privilege.
And I'm going to introduce for the record, when we finish these two text messages, so that Your Honor has those back there so that you can,
Sure. What would they be marked as?
what do you have?
I have a whole set, you can mark. Okay.
No.
I'm gonna go ahead and,
No, I think
Oh,
you're,
the
I
contract.
think you were.
Yeah,
The new one would be 26.
Yeah.
once I put a staple in it, I think it'll be Defense Exhibit 26.
All right.
You have to give me a real pen that works, not a line.
There you go.
All right, so this is marked and made part of the record as Defense Exhibit 26, but not necessarily for its
This is not admitted
evidentiary
26.
value.
It's for purposes of the court conducting the in-camera review.
Right.
And you put a staple in it here to make sure that you see. Yeah. No charge?
No, it's free.
Oh, geez.
All right, Ms. Sada, what else?
All right, so there was also reference, if I remember correctly, to some email correspondence in which Miss Merchant sent you the motion that she was going to file to disqualify Ms. Willis and Mr. Wade for your review. Is that correct?
That's correct.
Okay. And that was sent to you in an email?
That was correct.
And did you respond to it in an email?
I don't think I responded to her in an email.
Ashley, do we know?
He's responded by text.
You responded by text. I'm sorry, I mischaracterized it. You responded by text?
If I can look at my text, I can, but I'm assuming I did, but
Okay, I'm going to get it for you because
okay.
I don't want
All
there
right.
to be any assumption. As soon as we have it. Let me show you. This is the email. Here's, I don't have anything besides what I just handed you. And I will attempt to do it for this witness.
Listen, I always love your tone.
So you didn't have any hard copies of it?
If you want the truth to come out and make the audience, you can do it. Okay. Which is like, obviously, stop me.
Yeah. So
Anything else?
is that what you're?
I'm going to ask you about. Okay. I'm going to show you if I might approach. I made reference to an email that Ms. Merchant would have sent you about the motion she was going to file. If you look at this, does this appear to be the email that you received? It's dated January the 6th, 2024 at 10:20, can't make it as 5 or 6, 10:25 a.m.
yeah, I see it, the email. Yes.
So that's the email that you received. Along with the, obviously the attachment, which is referenced.
Yes.
Okay. And then did you respond to that email within the text message that I've just placed before you?
Yes, I said looks good.
So the answer is yes.
Oh, yes, I did.
Okay. We'll mark this as another exhibit for Your Honor to look at. Since you love my tone, can I have a slip on?
Realize I didn't read some of my nerves.
Oh, I'm sorry, I didn't catch that point. Someday I put the difference to it. Okay, I'm going to have these marked as 27. Okay? All right, so is it your position that what is reflected, let me hand it to you. Yeah. What's the course rule, to ask or not to ask?
We'll take it case by case. I think he's doing all right, so no need to ask for this witness.
Is it your position that your response, which is the second page of Defense Exhibit 27, is based on a confidential or confidential communications that you had with Mr. Wade?
Do you want me to read the response?
No, I'm only asking you whether or not the response, you actually already said what it said. I don't want you to read it again. Is that response, based on confidential communications that you had had with Mr. Wade?
Objection, this is privileged and cumulative.
All right, so now we're talking about the email, essentially referencing the motion as a whole. He hasn't been asked to actually confirm or deny any specifics, just to say whether his response was privileged. So I think we're just laying the foundation, just like we did with the text message. So you can answer that question, sir.
Was my response privileged?
No. Was your response to the email of Ms. Merchant, which is on page 1 of that exhibit, is your response, which is on page 2, is that based on knowledge that you received from Mr. Wade pursuant to confidential communications?
Yes.
Have you discussed with the district attorney's office this case, your purported testimony?
Of my testimony?
Yes.
No.
At all?
No.
No prep, no conversations, no nothing?
No.
Have you given your attorneys, for this matter, did you give them permission to speak with the district attorney's office?
Well, he can assert his own privilege, but that's kind of crazy.
Is there a objection to be heard?
Absolutely, this is
Okay,
privileged
sustained.
communication.
Mr. Stado, next question.
Do you know whether or not your attorneys shared privileged information with the district attorney's office?
No, I don't know what my attorneys shared or didn't share. I don't know if they even met.
Last question, have you spoken to Mr. Wade prior to today? No, actually, withdraw that. You're no longer in the same partnership or fee sharing arrangement with Mr. Wade, correct?
That's correct.
When did you leave that fee sharing partnership, pseudo partnership arrangement?
I don't remember the hard date, but maybe sometime like July, August of 2022, I think.
Okay. And what was the reason for the partnership or the fee sharing arrangements? What caused the separation?
I wanted to leave and go out on my own.
And that's the only reason.
I want to leave and go out on my own. Yes.
I understand, but that was the only reason. There wasn't any suggestions or allegations of any form of misconduct on either part, either on your part or Mr. Wade's part, correct?
Misconduct of what?
I don't want to try not to get into the specifics. Was there any allegations made of suspected misconduct on your part or on Mr. Wade's part? That's a fairly simple question. Did he accuse you of doing anything? Did you accuse him of doing anything? Without getting into what it is, were there any accusations made by you or him against each other?
We had a disagreement, yes.
Had that disagreement have anything to do with Ms. Willis?
Oh, no.
Okay. Did it have anything to do with your conduct?
No.
Did it have
But-
anything to do with his conduct?
Hold on, wait. So we had a disagreement. Whether the disagreement was, we disagreed. And so we dissolved, I left the firm.
And was the disagreement having anything to do with alleged or supposed misconduct by either one of you?
If you define misconduct, I'm telling you, we had a disagreement and
Just tell me what the disagreement was then.
the disagreement is mine to know. I mean, I don't see the relevance of the disagreement that I had. It had nothing to do with this Trump case or any other case.
I'm simply getting a question asked, what was the disagreement? It's not privileged, correct?
No, that is privileged.
Oh, it is privileged.
It
Why is
is,
that privileged?
because it's privileged. I can tell the court in camera, but it was privileged.
Ask a few questions further to see if this is actually something that does fall within that privilege. We can take it from there.
Did it have anything to do with you representing Mr. Wade in any capacity? Excuse me.
It would fall in that line, yes.
But your testimony is that it has nothing to do with your representation of Mr. Wade in connection with Miss Willis.
As it a connection to Miss Willis, that's correct.
It's connected to the matter for which you were hired by Mr. Wade?
I wasn't hired by Mr. Wade.
I thought you were the attorney representing him in the divorce.
Oh, I apologize. I thought you were saying something else. Oh, yes. So will it apply as to whether I was hired during the divorce? Yes, that's correct.
I'm not sure what this correct means under that. We kind of got lost on it.
You asked the question.
Did not relate to your representation.
It relate to my representation.
In the marriage case.
It does.
And this was whose decision was it? At that point, did you stop representing Mr. Wade?
It wasn't at that point, no.
Was it before that?
No, it was after that.
Okay. And how much longer did you represent Mr. Wade in the divorce action?
I'll have to see the divorce proceeding to see Mr. Wade. I represented Mr. Wade for a time after that. He represented me in a construction case for a time after that. And I will have to look at the filings. I ended up hiring new counsel for my construction case. He ended up, but it wasn't right at that moment. It wasn't in a matter of weeks. It was, I don't know.
Continued representing him in connection with the divorce case after you had the separation that you've made reference to.
He continued to, yes, and he continued to represent me on a construction case.
But the separation, at least in part, if I heard you correctly, and please tell me if I'm wrong, had something to do with your representation of him in the divorce case.
That is correct.
Okay. Now, Mr. Wade has testified that he did not have a relationship, a personal relationship, a romantic relationship with Miss Willis until sometime early 2022. Okay? I'm leaving that as the premise for what I'm about to ask you. Do you possess information that counters that, that's inconsistent with that?
Any information Mr. Bradley has would be privileged, Your Honor.
Okay, Mr. Sato, I think we've.
Would such
covered this.
information be privileged in your mind?
I think this has already been asked during Ms. Merchant's direct, so we're covering the same ground. So I'll sustain that.
So I can't get an answer to whether he possesses information which is inconsistent
No.
without getting into the information itself.
I think the issue would be that we've already gotten an answer on that, and now we're asking the same question again. Ms. Merchant asked him a variation of that, and he already answered.
I think the variation, Your Honor, is referencing whether or not he had what would be personal information, independent source information. Mine is not so limited. Mine is, I'm asking him point blank whether or not he has information from whatever source, including Mr. Wade, that is inconsistent with Mr. Wade's testimony.
Because if it includes Mr. Wade, it is privileged communication. So therefore, the answer is it's privileged. If it excluded Mr. Wade, that would be a different appropriate question.
Okay.
And I just want to say, the answer is either it came from privileged information or it's hearsay. That's it. He's already testified that he has no personal knowledge.
Unless it's for impeachment at this point, but Mr. Sato, I think that might be too fine a distinction for me to see the need for the question. I think I'm failing to see the difference.
Well, I'm not asking respectfully, I'm not asking you to see the difference. I'm asking whether I can ask that question and elicit a response which doesn't elicit the actual communications, which is what I'm attempting to do. And if Your Honor says
sure.
I can't, then I'm finished.
And I think that this was another aspect of what came up before, which is in my mind, even confirming the existence of the information goes into privileged communications, whether he does or does not possess information. If it came from that relationship, that's part of the privilege as well. So If I make that clear, then I'd
You're
be
sustaining what the objection would be.
That's right. It'd be sustained on privilege to that
And of course,
question.
all the questions that we're
Reserved for the
talking
record.
about as far as the foundation about when things are said and what is said, you're going to go into, if I understood correctly, ex parte in camera with the two exhibits we talked about.
That's right. My intent would be to make a record of the knowledge of when it was obtained and the extent of it and the different sources, and that'll be sealed.
And what was actually said.
That's right.
So I guess my question to the court before I sit down is if hypothetically you learn through this in-camera ex parte examination that the information that this gentleman has through the attorney-client privilege is in fact inconsistent with what Mr. Wade testified to under oath, then the court is going to then make a determination of whether it can be used here or whether it just remains in the record sealed.
So my intent would be to make the distinction of from the in-camera hearing, if I still determine that everything is covered by privilege, then anything else that is said cannot go into the factual determinations or credibility determinations that need to be made. And so just the issue of whether the privilege did or did not exist is preserved.
So again, just to follow through to make sure. So if the court knows that there's been a fraud upon the court through the lie of Mr. Wade, none of us are going to know that that in fact occurred, and the court's going to be in a position of making a determination on the motion, even though the court knows that it doesn't have all the information, truthful information.
I'll take a closer look at the case law you provided to see if that is actually a variation of the crime fraud exception. And I'll apply the crime fraud exception as I see it.
Right. And again, I'm not suggesting it is a variation. It is totally separate from crime fraud. It has nothing to do with using the legal advice of the attorney in order to commit a crime. It's you go ahead and commit fraud or lie to the court when you fully know that someone, your attorney, has information which is counter or inconsistent with what you've testified.
And to that end, Mr. Sadout, that is something that you can, I mean, I've got this case from Ohio, but if you can find something more on point in Georgia before we schedule
Other
this
than
for
the one
argument.
I gave you,
The Coca-Cola one?
the 1935 case.
The Atlanta Bottling Company? I don't think it went that far. I think it just kind of said the sword and shield language, and it didn't go so far as to say that there's this alternative theory about fraud upon the court, but we can flesh that out in our research.
I appreciate it. Thank you,
Okay.
Your Honor.
Mr. Stockton.
No questions, Judge.
Mr. Durham.
No question, John.
Mr. McDougald.
No question, Your Honor.
Mr. Rice.
Question.
Mr. Bradley, you were counsel for Mr. Wade in the divorce case when the interrogatories were initially served on opposing counsel on or about December 27th of 2021, correct?
That's correct.
And you were also counsel on for him when the amended interrogatories were served on May 30th of 2023, correct?
That's incorrect.
So you ceased representing him sometime before May 30th of 2023.
That's correct.
At any point during the divorce proceedings, was a pleading filed with the court or a paper served on opposing counsel that purported to have your signature that you were not the one that signed or authorized your signature on it?
Say that again?
Did anyone sign your signature without your authorization on any pleading or any other paperwork served on opposing counsel in the divorce proceeding?
I don't think so. If you have the documents, I can authenticate my signature.
And you have testified that you also practice criminal law and divorce law and perhaps other types of law as well.
That's correct.
And are you aware that OCG 16-6-19 defines adultery as a misdemeanor crime in the state of Georgia?
If you say so, yes, sir. Go ahead.
Okay, Judge, I would ask the court to take judicial notice of that.
For what relevance?
Judge, I think it does go directly to the crime fraud exception. Because before we draw objection, because if Mr. Wade was providing information to him, to his counsel about his intent to either commit adultery or that he was committing adultery, then that would be a misdemeanor crime. It would implicate the crime fraud exception. And additionally, as we know from yesterday's evidence,
Let
we
me
have
pause you
three-
there. Isn't adultery as a statute just on its face been found unconstitutional? You
It
can't
is-
actually charge anyone with adultery anymore.
It is still current in the
Then it
state of
can't be a
Georgia.
crime.
It is still a current charge.
Let's
in the
move
state
on
of
to that
Georgia.
next argument.
Additionally, Judge, with regard to the interrogatories, we have three different sets of interrogatories that were filed that came into evidence yesterday, 21, May of 23, December of 23, that contain false information. We also have the January of 24 that contains the invocation of privilege. So to the extent that this witness has information both with the original interrogatories that were filed in December of 2021, and frankly, with regard to the later ones, even though he wasn't counsel, that would be a false swearing and fraud on the court, which again is a criminal offense, and therefore the crime fraud exception would apply as well.
Okay. Understood.
No further questions.
Okay, Mr. Gillen.
Good afternoon, Ms. Bradley.
Good afternoon.
Been a long day. When did you sign your engagement letter with Mr. Wade to represent him in divorce proceedings?
It would have to be 2017, 2018. Same time frame, 2017, 2018.
So did you sign or have signed an engagement letter to represent him, or are you just speculating?
I can't recall. I mean, we were in a, we shared space. I can't recall if there was a contract or if there is a contract. I think there is a contract, but right now it would be speculation.
Right now, sitting here,
Mhm.
you do not know whether or not you had a signed engagement letter with Mr. Wade discussing the parameters of your legal representation of him. Isn't that correct?
That's not correct. I mean, I can't say I don't have my files or anything with me.
Well, sitting here, you do not have specific recollection or knowledge that you even had an engagement letter to represent him. Isn't that right?
I think I had an engagement letter, but I do not know specifically if I had an engagement letter.
Well, when did you open a file? Did you open when you represent someone, you open a file in your office? And when did you open the file on Mr. Wade?
I'm going to object to the relevance of this line of questioning. There has been no dispute from either the attorney or the client that there was an attorney-client relationship. And so I object to the relevance of the circumstances under which that engagement began, because as Mr. Gillen knows, that's not a factor in determining whether there was a true attorney-client relationship.
Well, Your Honor, it's not just up to Mr. Wade and Mr. Bradley, it's up to the court.
No, I agree with you there, Mr. Gillen, and so I'll give you a little bit of leeway, but I don't think we could spend too much time on this.
No,
So
okay.
We'll see.
Your Honor. Now, did you or did you not open a file in your law practice with Mr. Wade's name on it? Yes or no?
Yes, I had a file with Mr. Wade's name on it.
When did you open that file?
I'm assuming 2017, 2018. I can't tell you the exact date. I've said that 3 or 4 times.
Well, let's approach it from another angle. When is the first invoice that you sent to Mr. Wade for your legal representation?
I didn't send him an invoice in that capacity.
So what we have here is you're not knowing whether you even have an engagement letter, You don't know whether you actually even billed him, correct?
I represented Mr. Wade. I signed the documents that we filed. I filed the documents. There's depositions that I had with the um, divorce attorney that was representing his wife.
I'm sorry, sir, that's not my question.
Okay.
My question is, did you bill him in your capacity as the lawyer that you're telling him?
I
telling
don't
us that you
recall.
were- As a matter of fact, did you have any invoices where you billed him on an hourly basis?
I don't recall.
And the answer really is no, isn't it, sir?
I don't recall.
And the reason why it's no, isn't it, is because what happened is that you and Mr. Wade were in a law practice together, and it was a very small work environment, correct?
It was a work environment, yes.
A work environment where you and him would meet and talk literally every day, correct?
Not every day, no.
Well, almost every day.
Not almost every day. I stated earlier that I ran one side of a practice. Mr. Wade did, and we rarely were there at the same time. I stated that earlier today.
So well, just give us totally how much money you got for representing Mr. Wade in this since 2017 or whenever you told us up until you dropped off the case in 2023.
I don't recall.
Would the answer be zero?
I do not recall.
Well, you would know whether you got paid or not, wouldn't you, sir?
I do not recall.
So you don't recall whether you as an attorney got a single dollar to represent Mr. Wade, correct?
That's correct.
Because you really did it as a friend, didn't you?
No, I did, and that as an attorney.
Well, an attorney that wasn't being paid. You were doing it pro bono for a friend, weren't you?
I'm going to object to ask and answer.
All right. So I'm going to sustain that, Mr. Gillen. I think the law is clear that money doesn't even have to change hands for that relationship. And I'm making a finding based on the evidence that's already been presented, namely the fact that he signed pleadings, attended depositions on Mr. Wade's behalf, that attorney-client relationship did exist
Well,
at some
okay,
point.
Your Honor, I was just laying the foundation to the circumstances in terms of the non-billing from the 2017 period and whether there was really an attorney-client privilege there. That's what I was trying to do.
Okay. If the dispute is just when it occurred, you can try to hone in on that. But the questions I've heard so far are more from you were never paid ever. It was from a overall angle.
Well, from 2017 until November of 2021, you didn't receive a dollar from Mr. Wade for your supposed or your representation of him, correct?
I don't have the file in front of me, and I do not recall.
Okay. And the reality of it is, as I mentioned or asked you a few minutes ago, is that it was a small firm and you were doing him as essentially a favor as a friend and as a law partner, correct?
No, I was representing him as an attorney. Were we in the practice together? Yes. And were we, or are we friends? I mean, we were friends at the time. Yes.
Well, you were friends and law partners, correct?
Yes.
And in a small firm, and I know because I'm with it in a small firm, people will sit around the office and talk about their social life and what they're doing, correct? Correct?
If that happens in your small firm, yes, yes.
Well, does it happen or did it happen in your small firm?
Yeah, I'm gonna, the witness has been asked very specific questions about conversation about socialization, and we've gone on through it, so I think this is asked and answered.
All right. I'll let him answer this one question. Overruled.
Repeat the question.
Oh, did you in your small firm have occasion to where people would sit around and socialize and talk about what was going on in their lives as opposed to merely talking about the law?
Yes.
And you had those conversations with Mr. Wade as a friend on a social basis, didn't you?
I assume
Not yet, but it might.
I assume, yes, we've talked about sports. We talked about, sports a whole lot.
You talked about life and about what was going on in your life and what was going on in his life, right? Right?
Sometimes, very rarely, yes, sometimes.
And that is what you do in a small work environment when you know people very well and you do favors for them, correct?
I'm gonna object.
Yeah,
but
all right.
questions?
Sustain. Next question, Mr. Gillen.
Now, in that capacity, didn't you have discussions with Mr. Wade about what was going on in his social life that had nothing to do with him asking you legal advice?
Objection to be more specific.
I think he's just asked whether he socializes outside of legal advice. So I think you can answer that question.
I did answer the question. I said we talked about sports a lot.
And I'm asking, sports is one thing, the social life. Did you talk about each other's social life, like Mr. Wade, and who he was dating?
All right. So that'll be sustained on privilege.
Your Honor, and just for the record, I would state that my objection would be that the privilege only protects communications in furtherance of seeking out illegal advice, not talking about something that might be personal or confidential. And that's the distinction that I would draw.
I think that's a accurate legal point. However, I think the witness has already been questioned and testified on this point.
Thank you.
Next question.
Now, you got into the fact that you were the initial attorney on the divorce case, correct?
That is correct.
Now, did you and Mr. Wade, without getting into discussions, did you and Mr. Wade together prepare his responses to the interrogatories which were filed initially in the divorce case?
I'm assuming we,
Objection. He's asking about interrogatory responses, preparation of the case in the divorce case. That's all.
Mr. Gillen?
Well, I don't think it's attorney-client. Did they meet together? And when the interrogatory answers were filed, did he file them? And did he do that in concert with his client? There's nothing privileged there.
Did they meet and work together, and that work taking the form of them talking back and forth to each other on the right responses?
I'll change it a little bit. Did you review yourself the interrogatory responses given in the divorce case?
I did.
And whatever knowledge that you had when you were involved in the interrogatory responses, you had the knowledge of all that material or information that you had without getting into the content. You had all of that knowledge and information. I'm sorry, let me get my question out.
That's what I was trying to
he
say.
objects. And when you filed those interrogatories, you had all the knowledge and information that you had obtained from Mr. Wade from 2017 up until the date the interrogatories were filed, didn't you, sir?
Okay, so that's the follow-up question to that is going to be incorporating knowledge learned during communication. So I'll
Oh,
sustain
no,
on
I'm not going to have
privilege.
a follow-up question. I just want to know whether is that the case? When he filed the interrogatory forms, he had all of the information that he had discussed with Mr. Wade from 2017 up until the time. That's it. That's my final question.
Okay, in which case, without doing that extra assuming link that he based his answers on those communications, it has no relevance.
Well, it does in the sense that it shows what knowledge he may have had when he, the attorney, is filing interrogatory responses. That's what it shows.
Okay, I'm still not seeing the relevance of his knowledge as the attorney filing the responses, unless you're linking this back to
Well,
Mr. Wade.
it gets back, Your Honor, to whether or not, if you're an attorney and you're filing an interrogatory response, which you have reason to believe, or specific information to know that certain responses are not accurate, then you shouldn't be filing them. And now, so that's where I was going with that. So if he's got a body of knowledge over here that's built up from his communications with Mr. Wade that everyone so dearly doesn't want everyone to know about, in spite of the allegations made against Ms. Merchant. Now,
Okay, so what if the question was, did you, when you signed your name to the interrogatories, did you commit any knowing fraudulent statement and submitting those to the court at the time? Would there be a problem with that statement or that question?
Well, I mean, I think that is a conclusion that others could draw, like the court. I just want to know that he had all that information at the time that he, as the attorney, filed the interrogatories. That's it.
We would object. This does fall under attorney-client, and he is making presumptions about when information may have or not have been disseminated to Mr. Bradley in his capacity as attorney. He didn't have to know about anything at the time of, in the middle of, at the end of, or he may never have had that information. There's too much presumption associated with it. So the whole matter is covered under privilege.
One comment on that, Your Honor. We have spent almost a day talking about trying to block the dissemination of what Mr. Wade said, either as an attorney or in any capacity, about his relationship with Ms. Willis prior to November the 1st, 2021. And questions about discussions in 2019, all objected to, the claiming the privilege. And now to say, well, that doesn't mean that he learned something after. I'm talking about, what did you know at the time the interrogatories were filed? And everything that now they're claiming privilege, well, that's fine. The court will address that in chamber and in due course. What
Okay.
did you know?
I'm sorry, Mr. Gillen, I really don't see the distinction. So your question's noted for the record and your objection as well.
All right, and I'll follow up with this. Now, you're leaving removing yourself from the case, the divorce case, correct? You withdrew from the divorce case, correct?
Correct.
Did you do that as a result of your concern about any of the accuracies or representations which had been made by your client in the divorce case?
No.
Okay, so that's going to cover communications during the relationship?
Well, Your Honor, hypothetically, not saying this is the case, hypothetically, if Mr. Bradley, knowing, let's say hypothetically, that he speaking with Mr. Wade, was aware that the intimate or personal relationship, romantic relationship, existed prior to November the 1st, 2021, and started in 2019 or 2020, if he's armed with that information that he's obtained from Mr. Wade, but Mr. Wade would want to insist on responding to interrogatories which were contrary to the information that Mr. Bradley would have, then I'm asking him whether he took steps as an attorney to say, I cannot be a part of that or countenance that, therefore I'm withdrawing from the case.
Sure. I still see that as covering their communications. So I'll sustain that objection.
All right, well, thank you, Your Honor. That's all I have.
Okay. Thank you, Mr. Gillen.
Thank you.
Mr. Kacherov, are you still with us? Anyone on behalf of Mr. Floyd still joining us? All right, moving on. Mr. Cromwell.
Questions, Your Honor. I think everybody's exhausted with this line of questioning.
We're going, Mr. Bradley. When did you withdraw from Mr. Wade's divorce case?
I don't have it in front of me. I don't have the file.
Was it sometime in 2023?
No, it would have probably been, well, 2023. See, I left in 2022. It could have been anywhere between July of 2022 and maybe December of, it wasn't, I don't have the accurate date, but it wasn't when I left, and it wasn't.
Make it easier for you.
Okay, all right.
You were not his divorce lawyer at the time the interrogatory responses were filed in May of 2023. Is that true?
Oh, no, I was not. Okay, yes.
And as of today's date, Mr. Wade is still a married man. Would you agree?
I haven't kept up with the divorce proceedings, but I think they're still open.
So, and if they're still open, that means he's still a married man.
Yes, that's correct.
So if the fact that in a pleading, there's a reference to the marriage is irretrievably broken, that doesn't mean the marriage ends, does it?
I guess you have to ask the judge that's handling the case.
Well, it doesn't end until there's actually a divorce decree signed by a judge. Would you agree?
I would agree.
All right, thank you.
Okay, Ms. Cross, were you taking?
I am, Your Honor, and I'm going to have a minute. My cross-examination might be along a long one. So we've been going for about an hour and a half. I have just a 5-minute break.
Sure. All right. We'll be back in 5.
You're gonna take that room. You want him to go to back there? No, not with me. For you and your client to go back into the jury room. Yes. Yeah. Let it go there.
Yeah. They all call it. Yeah, they got called it back door. Back door. Oh, I'm sorry.
Okay, you want to go on that one?
Thank you, though. Appreciate the help.
So I just sent it to you.
I had the time to. But I didn't want to say love for you, so I oh, that's right. Oh, I wouldn't if it was looking. Oh, I don't even think it was. Stay down. It says this in the file. I never did it wrong. What's the Mickey? I'm gonna my.
Get it.
Somebody did that from the Okay.
We've been going in our. Yeah, no, we've been going.
Sorry. It's really tight here.
Yeah. That's a good way
Started at 9. And then we did a recess until 11. Okay.
Well, they did this because they want. But it's yeah, it's primarily directly in how that's what.
Oh.
Get me on the boat, get me on the boat dock.
That's qualifying.
At least what tour got.
I mean, she's. Well, that's not. I wasn't sure. Yeah. Only about a decade. I know. I'm just wondering. I mean,
No, it's not.
David just. Yeah. Okay, I was thinking of Oh, I know.
Will come to order.
Absolutely right.
What do we do?
We're on the record, yeah. Do we need to be on the record?
I just want to make sure what we do these huge record.
I believe just give those, we're gonna all have all of them. Okay, we're back on the record and, oh, maybe no, we're not. We can get Mr. Bradley back. While he's coming out, Ms. Merchant, for planning purposes, based on how Mr. Bradley's testimony was presented, do you anticipate calling any further witnesses? All right.
Oh, Mr. Fago had a copy of the for the church speech that I think he would have to just
Right.
drop back.
We'll handle that with housekeeping at the
Yes,
end.
okay.
Okay. Ms. Cross.
Yeah. Mr. Bradley, have you still got the exhibits 23, 24, 25 there in front of you?
I do.
And 23, that's one of the contracts for, that was your personal LLC or PC, your personal legal entity, right? For the
That is
district
correct.
attorney's office? Yes?
Yes, that's correct.
Okay. And I understood your testimony to be that any income that came into the partnership, when I say partnership, let me be more specific. You had an individual legal entity. Mr. Campbell had an individual legal entity. Mr. Wade had an individual legal entity, but y'all had a partnership agreement, right?
Yes, but we didn't have that the entire time.
There was
Yes.
a period of time that we've been talking, or that we had talked about in 2022, prior to you leaving the firm, that there was an actual entity for the three of you, correct?
That is correct.
And that was roughly during the time period where y'all bought a building together.
Yes, correct.
And it made things simpler. For whatever reason, you decided at that time that a joint entity made sense to own that building, right?
Correct.
Okay. All right. But those contracts there, they're not with the joint entity, correct?
No, they're not.
Those are all with you individually. Is that right? Can you take a look at 23, 24, and 25?
Yes.
They're all with you individually?
Yes.
Okay. 23. What's the hourly rate that you were being compensated? That was a.
23 is the I don't think, no, 23 is not the first appearance. 23 is the taint, it says.
What's the hourly rate on that contract?
150 an hour.
150 an hour? All right. So the 150 an hour, the way I understand you all shared profits was you'd get 50, Mr. Campbell get 50, Mr. Wade get 50, and then y'all pay expenses jointly as well, correct?
Correct.
All right. What about exhibit number 24?
It seems to be the same.
Same amount?
I don't know if it's the same amount.
I'm interested in the amount. Can you
Oh, no, the amount was 65 an hour.
$65 an hour?
Mhm.
That's not a particularly high rate for an attorney in the Atlanta metro area, correct?
No, it's not.
All right. Was that a government rate that you were willing to accept at that time?
Yes, that is correct.
All right. And so the $60 you're getting for that contract, again, that split three ways, you, Mr. Wade, and Mr. Campbell, correct?
That is correct.
So when you were
Minus
asked-
expenses and stuff like that, but yes.
Exactly. That was the income, and then expenses come from that, and then profits, whatever's at the end, correct?
Correct.
All right. So questions about Mr. Wade, I think the phrasing, and I object to it, but I think you might recall the question. Mr. Wade brought you this contract or Mr. Wade got you this contract? Do you remember those questions?
Yes, I do.
All right. So we're talking then about a split among the three of you of about $20 a piece, right? For that particular contract?
For this one, yes,
All right. What about 24? Have you got 24 there? I'm sorry, 25. Have you got that in front of you?
I do.
What's the hourly rate on that one?
It's 150.
150 on that one too? All right. And this same sharing went through the business, the way you handled that contract and as well, right?
That's correct.
All right. Who is Austin Dabney?
He was a probation officer that passed the bar, and we hired him and another individual. The other person didn't stay long.
And did Mr. Dabney and the other legal associate that you all had working for you at that time, did they do some work on these first appearance contracts?
Yes,
And that was a pretty good position for a younger lawyer to be sent to get some courtroom experience, correct?
that is correct.
2020, you're aware that Mr. Wade had a serious illness during that time?
I'm aware.
And you and Mr. Wade, I think you described your relationship in a lot of details earlier about specific circumstances, but you were business partners in, let's say, up till the time you left in summer 2022, correct?
That is correct.
You were business partners up until that time?
Yes, I said yes, that is correct.
Okay. And while you didn't socialize together frequently, you considered yourself a friend of Mr. Wade at that time?
Yes, we were friends at that time, yes.
All right. You are no longer business partners.
That is correct.
You are no longer friends.
I mean, if he's saying that we're not friends, then
I
yeah,
want to know what you think, Mr. Bradley. Do you consider yourself a friend of Mr. Wade?
I would consider.
Goes to potential bias. Ms. Cross.
Would I consider myself a friend of Mr. Wade? I would.
You were asked questions, Mr. Bradley, about the circumstances under which you left the firm. Do you recall those questions?
I do.
All right. And you left the firm. The firm remained the same as far as other employees, Mr. Wade, Mr. Campbell, as the named partners of the firm. You were the one who left, correct?
That is correct.
And you termed it as a disagreement. Do you recall answering questions as though you left due to a disagreement? Yes.
Yes,
And that disagreement was that there was an allegation of sexual made against you, correct?
that is incorrect.
There was not an allegation that you assaulted us, that you sexually assaulted one of the employees in the firm.
That is incorrect, but yes, yes,
Yes, there was an allegation that you sexually assaulted a member of the firm, correct?
yes, that was an allegation. Yes,
And as a result of that allegation, you left.
I did.
You were no longer business partners with Mr. Wade.
That is correct.
The firm remained intact, and in fact, the employee involved remained with the firm, correct?
I'm not certain of that. They did leave the building, of course. And I don't know, some of the employees did leave.
Mr. Bradley, you in fact paid that employee $20,000, correct?
That is that is incorrect as far as what was, no.
On or about the time that you left the firm, and on or about the time that the allegation of sexual assault was made against you, did you pay the person who had made the allegation of sexual assault any amount of money?
There was money left in an escrow that belonged to me. I don't know what that amount was.
And did that money that was left in the escrow that belonged to you, was that paid to the employee who said that you
I never gave any money. I left the money in the escrow account. What happened to that money? I can't, I don't know what happened to her.
For what purpose did you leave the money in the escrow account when you left the firm?
I left the money in the escrow account.
For what purpose, sir?
There was no purpose.
You just left the money in the escrow account?
Yes,
If there's no connection to the money you left in the escrow account and the allegations of sexual assault that an employee of your firm made against you, why was it that you brought to my attention, or why'd you respond the way you did about money in an escrow account when my question was, did you pay this employee any money?
I didn't hand any money. It was money from an escrow account, to my knowledge.
To your knowledge, where did the money in the escrow account go?
To the employee.
To that employee. Was there one allegation or one incident of sexual assault with this employee, Mr. Bradley, or was there more than one?
It's one incident.
Not two.
To my knowledge, there were not two incidents. No.
I'm asking for incidents that you have been involved in. Were there two incidents where you sexually assaulted this employee?
No, I didn't sexual assault anybody.
Was there another occasion where you paid any money as a result of an allegation of sexual assault against you?
No,
Did you sexually assault any clients of your firm?
no,
Never.
never.
Who's Anna Rodriguez?
I don't even know that name.
You don't recall a client named Anna Rodriguez?
Anna Rodriguez? No, I do not.
Never met her.
I do not recall the name Anna Rodriguez.
Your Honor, I would object to this. I'm not sure what we're trying to do here. So I would object to this line of.
All right, Ms. Cross.
Your Honor, this clearly goes to the bias that the witness has towards Mr. Wade and other individuals, his motive in
Okay.
involvement. And I believe it's an appropriate avenue to pursue based on exploring his credibility.
All right. At some point, though.
I'm not
And well-
planning to go much further.
Okay.
Judge, if this is allowed to continue in this way, and it does appear a little bit harassing, then is Mr. Bradley going to be excused from his privilege because this is not.
That's what I was gonna do. Don't do that.
Mr. Chover.
Sit on it. I think she's already done that.
Your Honor, I'm asking in all seriousness, that privilege, although.
Based on the answer right now, I think now we've opened up a whole area. What he has just responded to, he previously said was privilege. That doesn't sound like privilege to me. We'll have to address that when we go back through the rundown. So, Ms. Cross.
I'm finished.
Oh.
Okay. Mr. Sadow.
You were accused by Mr. Wade of misconduct in the course of your representation of Mr. Wade, correct?
I was not accused by Mr. Wade, no.
Who accused you? Did Mr. Wade not, based on the questions were just asked, did Mr. Wade not bring to your attention these sexual assault allegations?
Ask that again, please.
Mr. Wade brought to your attention the sexual assault allegations that you've been asked about by the prosecutor, correct?
Correct.
And at that time that Mr. Wade brought those allegations to your attention, you were still the attorney for Mr. Wade, correct?
Correct.
And therefore, your conduct as an attorney and the attorney at that time for Mr. Wade was called into question by Mr. Wade's passing along to you allegations of misconduct, correct?
I object to that. I don't think that's factually true. I don't know that that's not, I know that that is not legally true. The attorney-client relationship is of a matter. It is not vitiated by other instances or anything outside that matter.
I'm not sure that that's accurate. He was accused by Mr. Wade, his
Was not
client.
accused by
Do you
Mr.
mind
Wade.
if I speak? I allowed you to.
Mr. Sadow.
Mr. Wade accused this gentleman of misconduct in the performance of activity while he's an attorney working with Mr. Wade and representing Mr. Wade. Those allegations of misconduct open up the question of whether or not he can defend himself by now discussing his confidential communications with Mr. Wade in connection with the representation as well as the allegations. That's the position of the defense.
Understood. So what is the question you're putting? to
My
this?
question I'm going to ask him now is, tell us what Mr. Wade told you about when he began his relationship with Ms.
Okay.
Willis.
All right. So where I think we are with this is that Mr. Bradley previously testified that the reason he left the firm was totally and completely covered by privilege. When asked by the state, he went into a factual scenario that, to my mind, I don't see how it relates to privilege at all. And so now I'm left wondering if Mr. Bradley has been properly interpreting privilege this entire time. And I think the only way I can cure that is by having that in-camera conversation with him.
May I suspend my redirect for you to have that conversation?
I think that makes sense. But is there anything else though that you were going to cover other than this issue?
No.
Okay. Ms. Cross, any reactions?
Only to, Your Honor, the premise of Mr. Sadow's question was that Mr. Wade accused Mr. Bradley of the sexual assault. That was not my question, and I don't believe that's factual. Though there was an employee who accused Mr. Bradley of sexual assault.
Okay. But regardless, though, the point is that the circumstances of his departure from the firm, from what I've now heard, had nothing whatsoever to do with his representation of a divorce. Is that fair?
My question, I believe the testimony has been that the circumstances of Mr. Bradley leaving the firm were related, I can't say how much, but certainly in a large part, based on the allegation of sexual assault that was made against him by an employer.
Sure. And his previous testimony was that that was totally covered by privilege.
Yes, he lied.
Okay. All right. Other than this issue, which I think we've covered at length, was there any other questions based on Ms. Cross's examination from other defense counsel? Okay. All right. With that understanding, can this witness be excused, Ms. Merchant? All right. So, Mr. Bradley, I would ask, I don't know if we may be able to do it today. If we could.
Sorry, Judge, I don't think I can excuse him. Mr. Sadow had reserved the rest of his cross for after you determine the privileges.
Right. What I'm about to say just logistically is what I'm trying to do is if we can conclude this hearing with the exception of that in-camera hearing, we end for today. And if as a result of that in-camera hearing that I learned that we need to reopen the evidence, then that's what I'll do. So to that end, I can give Mr. Bradley instructions that he's to report back if upon order of the court, but otherwise, is there anything further the parties need from him today?
Yeah, but I wanted to get those sort of.
I know there's other housekeeping things and things we need to do.
And based on the testimony, you do have another witness, Your Honor. It doesn't involve Mr. Bradley
Right.
requiring to be here.
Okay, so now the state does have another witness.
I do.
Okay. All right. In that instance, okay, Mr. Bradley, you can step down, sir. However, I'm giving you the order to stay in touch with your attorney, and that we're going to have to find a time to meet again and go into an in-camera session. Do you understand, sir?
I do.
Okay. All right. Thank you, sir. You can step down. Ms. Chopra, do you have a card for me?
I do, Your Honor.
Okay.
At least I hope I do. I'm the worst lawyer on earth. I usually just tag bus stations with my.
You can write down your contact information for us?
I would.
All right. Ms. Merchant, do you have any further witnesses?
No, Judge.
Okay.
On the issue of the Bill Solinsky, 1006, first 611, we're not going to call him. We think the chart, the foundation of the source of the chart is sufficiently in evidence, and we can just use the chart
during argument under a 611 demonstrative.
Okay. And any objection to this entry as a demonstrative, Ms. Cross?
No, Your Honor, given the parameters we discussed earlier.
Okay. Can we go ahead and mark that an exhibit and make it part of the record in advance of argument, since I don't know when we're going to be able to have that scheduled. I think this would be Defense Exhibit 28. But let me go down the order just so we're staying organized. Ms. Merchant does not have any further witness. Excuse me. Ms. Merchant, on behalf of Mr. Roman, has no further evidence. Mr. Sadow.
Your Honor, we are in the process, if the court will allow us, to obtain certain phone records. And we would like the records kept open for the introduction of those phone records. We have them in draft. I say draft, we have them informally. We do not have certification yet. And they would deal with, you'll remember I asked Mr. Wade about certain activity down in Hayfield during a time period, and it deals with that specific time period. So we're talking about February to March of 2021 through November 1st.
And is it your intention that you would want to introduce these solely as an exhibit, or you think that this should reopen and bring us back for an entirely new evidentiary day with witnesses?
We would want to, if what we believe is there, based on our preliminary research, is there, we'd like to reopen and be able to introduce the records and someone to explain what they need. But that's it.
The state certainly, I'm sorry, were you finished, Mr. Sadow?
I believe so.
Thank you.
All right.
The state would certainly have an objection to that. This hearing has been set. We haven't seen the records, so I don't know if I have any objection to what they are. But the day has been set for quite a while, and we object to leaving the evidence open for any purpose.
Okay. And Mr. Sadow, when did you first go about trying to obtain these records?
I know it's also the Delta records. As soon as we got a hearing date and the state's response, so what happened was when the state responded, I think it was February 9th, and admitted to the relationship, but put parameters on the timing. I sent subpoenas out in response to that. So that was February 9th. Problem is Delta, AT&T, all these folks aren't super fast about that. And so I know Delta, we're also waiting. I wanted to remind the court, waiting for those records to be submitted in camera. Yes. And AT&T actually emailed me these phone records yesterday morning on the way to court.
Okay. All right. Any further exhibits that are self-authenticating? If counsel are able to provide those, obviously serve those on opposing counsel, and then before sending them over to us, let us know whether they would be tendered with or without objection, just purely on authentication or hearsay issues or relevance. We can make those part of the record, and I'll reserve whether this reopens a full hearing format, but the exhibits themselves I'm willing to have come into the part of the record, but there will be a cutoff point very soon, as soon as we schedule argument. All right. Any other evidence, Mr. Sadow, then? So that would be cell records. Mr. Stockton, any evidence? All right. Mr. Durham, if you're still with us.
No, Your Honor.
All right. Mr. McDougald.
Copies I mentioned to Your Honor yesterday, Your Honor.
Okay. And why don't you lay those out for the record?
They are marked but not yet numbered. I believe our next exhibit would be 29.
28, I just said, was Mr. Gillen's demonstrative, just so I'm keeping it straight.
And so I previously provided these to the prosecution. 29 would be a certified copy of County Code Section 2-68.
Okay.
30 is a certified copy of County Code Section 2-69. 31 is a certified copy of County Code Section 2-79. 32 is certified copy of County Code Section 10-114. 33 is a certified copy of County Code Section 10-115. 34 is a certified copy of County Code Section 102-464. 35 is a certified copy of County Code Section 102-465. 36 is a certified copy of County Code Section 102-466. And 37 is a certified copy of a emergency motion by non-party deponent for protective order filed on behalf of DA Willis in the Wade divorce case.
Okay, Ms. Cross, objection to defense exhibits 32 through 37.
I object to their relevance, and I will take I would take opposing counsel's representation that the pleading is complete and accurate as it was filed, and object to the relevance of that as well, but not the authentication.
Okay, all right, we'll note the objection for the record and we'll admit them for whatever weight they're due. So defense exhibits 32 through 37 are admitted. If you could hand those to Madam Court Reporter. Any further evidence, Mr. McDougall? Okay, Mr. Rice.
No, Your Honor.
Mr. Gillen, the demonstrative 38 or 28? Okay, and do you have a physical copy for us already? Great. All right, do we still have Mr. Kucherov with us on Zoom or anyone else on behalf of Mr. Floyd? So he's not on any longer? All right, I'm being informed that he dropped off Zoom, and so I'll make a finding that he voluntarily has absented himself from this hearing. Mr. Cromwell.
No evidence, John.
Okay. Ms. Cross, back to you.
If the defense presentation of evidence is done, I'd ask that all of the witnesses who had been subpoenaed but not called now be released.
I think that's fair. Ms. Merchant, any reason to hold on any of those witnesses? Okay.
The state has 2 short witnesses, and that is it.
Okay, you may call your next witness, Ms. Cross.
Next witness for the state is Austin Dabney.
These witnesses are going to need to be
Impeach. Maybe impeach the testimony of Mr. Bradley?
on a collateral matter. We'll wait and see.
Yeah, we don't have there.
Okay.
I do.
Yes, my name is Austin Dabney. That's AUSTIN DABNEY.
Good afternoon, Mr. Dabney.
Good afternoon.
I want to direct your attention, well, first of all, how are you employed?
I am employed right now. I have my own firm.
You're
So
a
I'm-
lawyer and you've got your own law firm?
That's correct.
All right. I want to direct your attention to 2021, 2022. What was your employment at that time?
Yes, I was employed with the Wade Bradley Campbell firm.
And that's Nathan Wade, Terrence Bradley, and Chris Campbell?
That's correct.
All right. And what did you do in that firm?
I was an associate attorney.
All right. And don't need a whole lot of detail, but generally speaking, who in the firm did you work for? What kind of matters did you handle?
Well, I believe I worked for all of them equally. They would all give me tasks to do, which court dates to go to, what cases to work on.
I want to direct now your attention, Mr. Dabney, to a particular instance. Did you have occasion at any time to go to a club with Mr. Bradley?
Could you repeat the question?
Yeah. Did you have any occasion to go to a club, a nightclub or a bar situation with Mr. Bradley?
Yes, I have.
More than one time?
More than one time, yes.
The time that I'm going to direct your attention to, we spoke about a little earlier today.
Mhm.
Do you recall any instance, Mr. Dabney, where Mr. Bradley, where you witnessed Mr. Bradley sexually assault anyone?
Your Honor, I object to this. This kind of
Okay.
specific instance of
Sure.
impeachment is improper.
All right, how is this not extrinsic evidence of a collateral matter, Ms. Cross?
Maybe ask a better question. My question will be, if this witness witnessed Mr. Bradley sexually assaulting another employee of the firm.
It's the exact, but same subject matter. How is that not issue on a collateral matter for impeachment?
I think it's not a collateral matter. Your Honor, the witness denied it. I think it is highly relevant. I think that it goes to the witness's credibility and his denial here this afternoon that he committed the assault. There's a witness I will proffer to the court who has firsthand knowledge and witnessed the event. And so I think that's highly relevant to both Mr. Bradley's credibility and to the proceedings that we've had for the last 2 days.
Still object, Your Honor.
Oh, I understand, Mr.
Attempt to impeach Mr. Bradley, they have to live with whatever answer he gave. They can't have a sub-trial with evidence of misconduct here, so we would object.
608A. And again, right?
608.
Or 608A.
Yeah. Ms. Cross, under 608, I don't see how this isn't well beyond the core facts at issue. I think you confronted with him. I think he answered them as he saw fit. An argument can be made as a result, but to go down a whole mini trial on whether and he did or did not do this and the circumstances of his leaving the firm, I don't see how that gets past 608.
I understand the ruling, Your Honor. Disagree, and just for my objection, I put a proffer on the record, not a detailed one, but that
I think you already have.
I'd like to, with the court's permission, I'd like to make it clear that the sexual assault I'm referring to was the same employee that I asked Mr. Bradley about. I just wanted that to be clear in the record.
Okay. All right. Understood. Is there anything else that is relevant to this witness?
Given the court's ruling, no.
All right. Questions from defense counsel?
Good afternoon, sir.
Good afternoon.
When did you start working at the law firm?
I believe I started working, to my recollection, in March 2021.
Okay. And at that time, do I understand that there was what I would call a three-way partnership or sharing arrangement at the law firm?
I'm not aware of any sharing arrangements that they had, but it was the Wade, Bradley, and Campbell law firm.
And did you work in the law firm office on a daily basis?
I did.
And during the time period, you were there for the remainder of 2001? That is, you worked from March of 2001, at least to the end of 2001, correct?
I didn't even have a bar license in 2001.
I'm sorry, 2021. It's a little late. From March of 2021 to the end of 2021, correct?
That's correct.
Okay. During the time period that you were working at the law firm, did you see Fani Willis?
During my time, could you repeat the
In that
question?
time period between March of 2021 and November 1st of 2021, did you see Miss Willis?
I may have recalled one instance where I saw her in passing.
And when you saw her, was she at the law firm?
That would be correct.
And do you know who she went to visit?
I do not know.
You didn't see her go to Mr. Wade's office?
I do not recall.
Did you ever talk to Mr. Wade about Fani Willis?
Could you repeat your question?
Did you ever talk to Mr. Wade about Fani Willis during the time period of March of 2021 to November 1st of 2021?
No.
Did you know they were dating?
No, I did not.
Did you see anything did you ever socialize with Mr. Wade?
As far as being an employee, yes.
Well, I don't know what that means exactly, but did you ever go out to eat with Mr. Wade?
On occasion, he would take the office out to lunch.
Beyond that, did you ever go to a nightclub or drinking or any of that with him?
No, I did not.
Okay, so whatever relationship Mr. Wade had with Miss Willis during this time period, you don't have personal knowledge, correct?
I do not have any personal knowledge.
Thank you very much for being here.
Thank you.
Any other questions from defense counsel? Mr. Stockton?
When you started in March of 21, was that just you gave them a resume and started working there?
I don't understand your question.
When you started working there, is it a situation where your first day on the job was the first day you may have met him or shortly before you met him?
Again, I don't understand what you're asking.
Let me, did you know Mr. Wade or any of his partners prior to March of 21?
Yes, I did.
How did you know them?
In a professional capacity. I used to be a community supervision officer with the Georgia Department of Community Supervision,
And where would that have been out of Fulton County?
Cobb County.
How long did you know Mr. Wade prior to that?
I didn't see Mr. Wade in my professional capacity. I thought you were asking about all partners, but if you're only asking about Mr. Wade, if you could please clarify.
Okay, so you went to work for Mr. Wade in March of 21, correct?
I went to work for the Wade Bradley Campbell firm.
Okay. Prior to that, how long did you know Mr. Wade?
I did not know Mr. Wade prior to that
At all?
at all.
No further questions?
Any other counsel? All right, seeing and hearing none. Any redirect, Ms. Cross?
No, Your Honor, subject to the court's ruling.
All right, can this witness be excused?
Okay.
All right, thank you, sir.
Thank you, Your Honor.
Next witness, Ms. Cross.
I believe I know the court's ruling, so let me proffer that the next witness the state would call would be Anna Rodriguez. Question, Mr. Bradley, about a sexual assault of Ms. Rodriguez, a client of the firm. You denied knowing her or recognizing her name. I believe Ms. Rodriguez's testimony would be impeaching of Mr. Bradley. I believe it's appropriate, but want to present that before I call her.
All right, thank you, Ms. Cross. And so based on that proffer and the subject matter proffered, I still believe that would fall under 608B as extrinsic evidence of a collateral matter. And so I don't think it's allowed under our rules of evidence.
Understanding that, I just make a proffer on the record that Ms. Rodriguez would testify that Mr. Bradley sexually assaulted her. She was a client at the time. And that would be impeaching of his testimony that he did not do so.
All right, understood. Any further evidence or witnesses, Ms. Cross?
No, sir.
Okay. All right, then at this time, for now, I'll consider the evidence closed, subject to any certified submissions by counsel and subject to the results of the in-camera hearing. We will coordinate with all counsel to find a date to come back for summation. And to that end, again, using Ms. Merchant running lead on this, I'd like you to consult on whether that's going to be a collective response on behalf of the defendants. If not, then we're going to have to get into time allotment. And if it's more than a handful of counsel, it'd probably maybe be 10 to 15 minutes per side. And so, Mr. Sadon.
When did you say this might happen?
We'll follow up by email so we can coordinate with everyone's schedules. I want to make sure we have our same court reporter as well, so that the record is all in one place. And I know we have a lot of schedules to coordinate, but looking at either late next week, as in next Friday, or the following week.
We at least have the opportunity to get a transcript before we do that.
I think that's probably highly unlikely, but we'll see. It's just that would require a rush, and I know again we're at a shortage of court reporters, but I think there are other means you can refer to the evidence with confidence as to what was said. Ms. Merchant.
Next week.
Okay.
You said
And
next
like I said, we will. We're gonna follow up with scheduling. Mr. Gillen.
The argument would be on this hearing,
And
so on the forensic.
yeah, any other claims brought in any of the filings regarding forensic misconduct, this whole line of questioning? All right. Any other questions from defense counsel? Anything from the state?
Just ask that we be allowed to submit a brief as it relates to the rulings that you just made as relates to the objections by defense counsel under 607 and 6021, which would be impeachment by contradiction, which in the state's understanding would allow the use of extrinsic evidence to impeach the specific testimony here of Mr. Bradley. So we're just asking for leave to provide a brief and have the court to further consider your waiver.
Well, if you still got your witnesses here and you think you've got a better legal argument, I'm willing to hear it. You said 607 and 608.
7 and 621.
Okay, I see 621 and I see 608. And
In both of those instances, they allow testimony that related to the testimony of another witness here, Mr. Bradley, that proved as patently false, as he testified that he didn't commit a sexual assault and that he didn't pay off witnesses and things of that nature.
okay, and how do you get around 608B's prohibition on extrinsic evidence of collateral matters?
Both 607 and 621 allow the use of extrinsic evidence to specifically impeach facts known to be false.
But if that held true, respectfully, that would mean that any time a witness denied something, you'd be able to, of a matter testified to, you'd be able to impeach evidence. And that's not.
Well, here's what I'm fine with, Mr. Abadi. If you want to submit that brief on purely legal argument, you can, but I don't want to have this as a vehicle to essentially put forth an extended and long-winded proffer of what you expected the evidence to be. So if you think I've made a legal error on that point, feel free to brief it, and we can reopen the hearing if that's legally invalid. Okay? All right. Mr. Chopra, is your client still here?
So, Your Honor, but I'm sorry, they went into the.
That's fine. If he is still here, let's relocate to the jury room.
Certainly.
Okay. We will be adjourned for today. Thank you all.
I love all.
Ms. Taylor, I don't, it logged out on me. Do you think it, do you think it lost battery or? I don't know. I mean, I don't need it now, but, where are you going to put the exhibits? That'd be great. Yeah, or I can just get the scan. Probably easier for me just to look through the PDFs. Yeah. And then, are you in a rush to get out of here? If we still have,
And it may not even be.
we still have 30 minutes.
It's not mine.
Maybe we can get started and see where. So, well, I was gonna say, here's a way you can read it. I wanted to take the relocate machine. Let me see if it's still here. So,
Nice meeting you.
Yeah, that you met Mr. Abate. I'm so sorry. That's messed up. I thought I was.
Well, my first meeting, was,
I would sure hope so. Well, I don't know if she'd have enough jails to fill.